Motion number 3 on business of the House today. Minister to move.
Move formally.
The question is as on the order paper. The question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Motion number 4 on Northern Ireland. I call the Minister to move the motion. Hilary Benn.
Madam Deputy Speaker, I beg to move that the draft Northern Ireland Troubles, Legacy and Reconciliation Act 2023 Remedial Order 2025, which was laid before the House on the 14th of October 2025, be approved. As every one of us knows, Northern Ireland continues to live with the legacy of the Troubles. Over 3,500 people lost their lives during that period of brutal violence, including almost 2,000 civilians and over 1,000 people who were killed whilst bravely serving the state. And we owe them, and always will, a huge debt of gratitude. 90% of all those who lost their lives were killed by paramilitaries. Each person was someone's father, brother, sister, mother, or child. Each one a tragic loss of life. In 1998, the people of Northern Ireland chose to leave this legacy of violence behind them when they voted for the Good Friday Agreement. But for too many families of the victims, questions remain as to why their loved ones died and at whose hands. There have been many efforts to address the legacy of the Troubles since, including the Stormont House Agreement, reached between the last government and the Irish government in 2014, and most recently the 2023 Legacy Act. It is now beyond doubt that this last attempt, the Legacy Act, whatever its intentions, fundamentally failed. It failed because it has been found in many respects to be incompatible with our human rights obligations. The legislation simply did not work in its own terms. But even more importantly, it failed because it did not command any support in Northern Ireland amongst victims and survivors or the political parties. Well, I will give way, yes, of course, to my honourable first, and then I will give way to the honourable member.
Laura Anderson.
I thank the Secretary of State for giving way, and I commend him on the careful work, the thoughtful work that he has done to bring the House to this place today. And does he agree with me that in this he's doing the right thing for victims? That means ordinary people, Madam Deputy Speaker, including veterans and the wider armed forces community, all of whom were injured or lost loved ones, and they're the people we have in our mind today. It was the Conservative bad legislation that led us to having to do this remedial order today, and it's only the 11th time this has had to happen since the Second World War.
Order. This is a very long intervention. There are many speakers wish to get in this afternoon. Can I urge members to keep interventions short? Secretary of State.
I do agree with my honourable friend that the Legacy Act needed dealing with. Any government that came into office in the summer of last year would have to be doing what we are doing. I give way.
So for giving way, if we need to repeat it, it's worth bringing to the attention of the House again that the Legacy Act, legality or otherwise, was predicated by the membership we have of the ECHR. And would he agree and would he reflect on the fact that there was an appeal against the supposed illegality of the Legacy Act at the time of the general election by the previous government, that this government decided to ditch?
That is indeed a wholly accurate description of the sequence of events, because this government does not agree with immunity as a matter of principle. I go on to advance the argument a little later on. But it was also as the honourable gentleman points out, found to be incompatible with our obligations as a nation because we continue to be signatories to the European Convention of Human Rights. I will give way, yes, of course.
So he's a immensely courteous member of this House and always has been. You were aware that there is a live legal case, however, by the Northern Ireland Veterans Movement, and the very Human Rights Act, which he cited, says that these kind of orders ought not to be moved, indeed would be ultra vires, while a case is proceeding. How does he feel about that, and would he explain to the House why we're debating this at all, given all I've said?
Well, I'm very grateful to the right honourable gentleman for raising that point. If he will bear with me, I will come very directly, a little later on in my speech, to precisely that point. Therefore, it is the government's view that there is both a legal necessity and an imperative for us to act, and this remedial order is the first step in that process. Now, the remedial order will remove two key effects of the provisions of the Northern Ireland Troubles Legacy and Reconciliation Act 2023, which were found by the courts in Dillon to be incompatible with our human rights obligations. One of the main reasons for the failure of the Legacy Act was its attempt to grant immunity, including to terrorists who murdered in cold blood soldiers and civilians in Northern Ireland and in towns and cities across England. Now, it probably, in fairness, seemed reassuring to veterans. It was almost certainly reassuring to terrorists who had committed those acts. But it was a false promise, and it protected no one. It was never commenced. Very important fact. It was never commenced. It was rejected by the courts as being incompatible with our legal obligations, and as a result, it was never implemented. No one ever got immunity, and while it may remain on the statute book, in practice, it does not exist. Nevertheless, while it has not been commenced, for many families, any uncertainty about their loved ones' killers being granted immunity has been a deterrent to coming forward to seek answers from the Independent Commission. There has also been opposition from some who served in Northern Ireland, because immunity undermines the rule of law that they were seeking to uphold. As David Crabb, a UDR veteran who sits on the Victims and Survivors Forum, said of immunity, and I quote, "The vast majority of veterans living in Northern Ireland did not want or feel as if they needed this protection. It was viewed as a perversion of the law that went against the ethos of what those who served stood for and what their role was in preserving law and order." And it was not only a false promise, it created a false equivalence between veterans on the one hand and terrorists on the others. And it still technically sits on the statute book today. I will give way to the right honourable gentleman.
May I just remind the Secretary of State, because I know that he knows it, because he's heard it from me and others many times before, there was nothing about creating a false equivalence between the two. Everybody is equal before the law, and if anything created a false equivalence, it was the 1998 Northern Ireland Sentences Act, which said that no matter how many murders a paramilitary had committed, and no matter how many illegal acts, if any, a soldier had committed, neither of them would ever serve more than 2 years of a sentence. Yeah. So that equivalence is there. It's not moral equivalence, it is equivalence before the law, and this bill did not initiate it.
The right honourable gentleman is absolutely right when he describes the provisions of the 1998 legislation, but as he knows, that policy, along with the rest of the Good Friday Agreement, was supported by just over 70% of the people in Northern Ireland, in the referendum that took place. And it was a very bitter pill to swallow. It was a very bitter pill to swallow for many people in Northern Ireland, but it was a price to be paid for the peace. The point I am making in relation to this remedial order is that the last government chose to legislate to give immunity to veterans and to terrorists on the same basis. And as the noble Lord Dodds said about the legacy bill, which, by the way, he described as rotten, and I quote, "It basically elevates terrorists and perpetrators of violence above their victims. That is fundamentally wrong." And that is why we're bringing forward this remedial order, to remove those provisions on immunity which have done so much damage to trust in Northern Ireland. Doing so will provide clarity and certainty ahead of the wider significant reforms contained in the Troubles Bill. Now, Madam Deputy Speaker, the remedial order will also remove the bar on Troubles-related civil cases which stripped UK citizens of their right to seek redress. Section 43 of the 2023 Act left some 800 Troubles-related civil cases involving the MOD untouched. The Act allowed them... I will give way, yes, of course.
He may shortly be coming on to this in his speech, but civil cases have been raised as a concern as potential for lawfare, notwithstanding that obviously people like Gerry Adams are also subject to civil action in the coming months. Would he give an outline of what he expects in terms of civil cases against those that served in our military and our security services?
Well, I'm very grateful to my honourable friend for that intervention. These 800 cases were untouched. The Act allowed them to carry on. It's a very important point, given some very inaccurate press reporting that appeared at the beginning of this week, that I'm sure many honourable and right honourable members are aware of. But it did stop about 230 new civil claims from proceeding. Those were claims that were lodged after the date of the first reading of the Legacy Bill, about 120 of which are against the MOD, and it prevented any more claims from being brought in the future. The point I'm making is there are 800 cases already there left untouched by the Legacy Act of the last government, and there's 120 against the MOD that have been added since that will be enabled to proceed if the remedial order passes. And as we know, this bar on new civil cases was found by the courts to be incompatible with our legal obligations. Now, bringing civil... I will give way to the right honourable gentleman, of course.
Well, to the Secretary of State, and I do intend to return to this in my contribution later on, but the issue around civil cases highlights most starkly for this House the discord even between the courts. The High Court in Belfast only focused on the retrospective application of the provisions on civil cases. It was the Court of Appeal that then said not only should it not be retrospective, it should have no application in the future as well. There was a disagreement between both courts, High Court and Court of Appeal, about the import of this, and yet the Secretary of State, more determined to pursue his policy objective than the law, decided not to appeal that issue at Supreme Court. That's why there are questions around the appropriate nature of this remedial order. Does he accept that?
Well, I accept, first of all, that it's not unusual for higher courts to take a different view on a matter from lower courts. That is the way the law works. I would give the same answer to the right honourable gentleman I gave to the earlier intervention. That is the government's view that citizens of the United Kingdom should be able to bring civil cases as a matter of principle. He may disagree, but that is the view of the government, and that is why we withdrew the appeal in relation to that element of the judgments to which he have just referred. And we should remember that bringing civil cases has included family members of victims who were murdered during the Troubles, who've been against the paramilitaries who were responsible. 4 individuals were found by a civil court to be responsible for the Omagh bombing in 2009. There's also been a civil case looking into the Hyde Park bombing, where John Downey was found to be an active participant in the killing of 4 soldiers, and has been referred to a moment ago. A civil case against Gerry Adams is due to take place in London this year. And so, if it just let me finish the point. And therefore, to vote against this remedial order would be to prevent any more such cases being brought against paramilitaries in future. I will give way.
Thank you. As he well knows, the Blair government handed out hundreds of so-called letters of comfort to alleged IRA paramilitaries following their release from prison. John Downey, the alleged Hyde Park bomber, produced such a letter during his trial at the Old Bailey, whereupon the trial was immediately abandoned. Our Northern Ireland veterans have no such letters of comfort. Does the Secretary of State agree that that letter of comfort let John Downey off on that particular occasion?
Well, as the honourable gentleman, I'm sure, is well aware, Mr Downey in that case was issued with a letter of comfort wrongly. Because the letter said, we're not seeking you for anything, and clearly the state was seeking him for something because he had been charged with the Hyde Park bombings. And as I recall, the judge said, well, I'm afraid this is an abuse of process, and stopped the case. However, if the right honourable gentleman stopped the case. However, the letter that Mr Downey received did not give him immunity, because he is currently, this is a matter of public record, he is currently awaiting trial, charged with the murder of 2 soldiers in, I think, 1972. And that proves what many people have said, former Prime Ministers, the Chief Constable, judges, they've all said the letters of comfort, the on-the-run letters, did not grant, never did, and do not now grant anybody immunity. I give way to the right honourable gentleman.
The honourable gentleman, of course, changes the subject, as it were, from what the letter of comfort was given for to what it was not given for. So it doesn't prove anything about the letter of comfort. What is the case is that the judge at the time said he could not prosecute, or he could not rule on this case, because the state had made a promise to Mr Downey, and that prevented the case. As, indeed, we have also Queen's Grant of Mercy. That's also an amnesty. And we also had people released early. That's also an amnesty. So for him to say that the Good Friday Agreement did not involve amnesties is simply a defiance of the facts.
If we are going to get on to the facts, first of all, the early release scheme was part of the Good Friday Agreement and the legislation. The people of Northern Ireland voted for it in knowing what it involved. On the royal prerogative of mercy, those were granted. They were never pardons. The convictions of those who received them were never quashed. They were put in place to allow those individuals who, for technical reasons, could not be eligible for the early release scheme. That is the history of that. And in relation to the letters of comfort, the right honourable gentleman, who is very learned in these matters, has not challenged the basic argument that I've put, which is the fact that Mr Downey is currently awaiting prosecution proves that that letter he received did not give him immunity from prosecution. Now, we cannot, I'm going to make some progress, we cannot and should not allow the victims of the Troubles to be denied redress through the courts. That's our view of principle. I recognise that the right honourable gentleman, the leader of the DUP, takes a different view. I now want to turn to the argument that the House should delay approving the remedial order, which we did hear advanced in the House before Christmas. Section 10(1) of the Human Rights Act 1998 allows a remedial order to be made on 2 grounds. First, if there has been a declaration of incompatibility in relation to a provision of legislation and an appeal against the declaration has been determined or abandoned. Abandoned is a really important word here. And secondly, if there are compelling reasons to do so. The Northern Ireland High Court clearly made a declaration of incompatibility in relation to immunity, and in July 2024, the government, the newly elected government, abandoned these aspects of our appeal. The government is therefore clear that the issue of incompatibility for the immunity and indeed the civil claims provisions are no longer part of the appeal now before the Supreme court, I will give way, of course.
Of course, the Secretary of State needs to go back to what the High Court judgment said in the Dillon case. And if he goes to paragraph 710, he will see that the basis of ruling that immunity was unlawful was not just in respect of the ECHR, but it was also in respect of Article 2 of the Windsor Framework. That aspect, which is wholly intertwined with this question, is the subject of appeal presently before the High Court. So how can it be that if a challenge which caused the High Court to decree that something was non-applicable was based upon the applicability of Article 2 of the Windsor Framework, and the government, and there is an appeal on that point, how is that not something that rules this order out under Section 10?
Well, it doesn't rule it under Section 10 for this reason. There are two parts to the court's ruling in relation to immunity. The first part was the court found immunity to be incompatible with our international human rights obligations. The government withdrew an appeal against that finding. That finding remains, and that gives the government, because the appeal was abandoned by the government, that gives the government the right to proceed with the remedial order. The second part of the judgment was, in addition to finding the immunity provisions incompatible with the ECHR, the court decided to strike them down under Article 2 of the Windsor Framework. And the Honourable Gentleman is quite correct that the government is continuing with the appeal in that respect because there is a genuine argument, and it's one that the government has advanced, as to, well, is Article 2 really being interpreted in the right way? Because it seems like rather an expansive interpretation. And I would go on to say that the fact that the Northern Ireland Veterans Movement was granted permission to intervene in relation to the interpretation of Article 2 of the Windsor Framework, because that's what the court allowed them to come in and talk about, and the court is considering the question of the interpretation of Article 2, it does not and cannot alter the fundamental legal reality that immunity has been found to be incompatible with the European Convention. And section... Well, I will give way. I'll give way. The two honourable members I've seen standing, and then I'm going to bring my remarks to a close so others can contribute.
Could I refer the Secretary of State to what paragraph 710, subsection 2 says of the Dillon judgment? It says, pursuant to Section 7A of the EU Withdrawal Act 2018, Article 2 of the Northern Ireland Protocol Windsor Framework has primacy over these provisions, thereby rendering them of no force and effect. These provisions, therefore, should be disapplied because of Article 2. And Article 2 is before the Supreme Court. So it is inextricably linked to Section 10.
I disagree, and I tried to explain in answer to his first intervention. He is right in what he reads out in relation to Article 2, and that is the subject of a continuing appeal. But the declaration of incompatibility under the ECHR, because the court ruled both of those things, remains. It is not at issue in the appeal, and that gives the government the ability to bring forward an order under Section 10. I will give way to the honourable gentleman, and then I'm going to bring my remarks to a close.
I'm grateful to the Secretary of State for giving way, and it's all getting quite technical, so I just want to come back to the fundamentals of justice. Would the Secretary of State, if he were able to, like to give immunity to our veterans?
Well, I am of the view that I listened to what I quoted what David Crabb said earlier, who was opposed to it. The government has listened to what the Veterans Commissioners have said, and indeed many others have said. We don't want immunity. We're not calling for immunity. We want fairness under the law. And I have made clear to the House, and it is a difference of view, but I have made clear to the House that the government does not agree with immunity as a matter of principle, because when our brave soldiers put on the King's uniform, they're operating under the law, they're upholding the law, and they operate underneath it. And as Ben Wallace, the distinguished former Defence Secretary, said, we abide by the rule of law. That's what makes us better than the terrorists. Now, Section 10 also requires that I have compelling reasons to proceed. And whilst the government has indeed introduced primary legislation, the government is clear that these repeals need to happen as quickly as possible. Why? Because we need to provide clarity on immunity to build trust amongst victims, survivors, and indeed veterans in the Independent Commission. Because while immunity remains on the statute book, it'll be harder for them to obtain the confidence of some victims and survivors. I'm going to continue. Now, I've tried to cover the point that some have argued, particularly in the other place, that we should delay the remedial order until the Supreme Court ruling in Dillon. I would just say it's really easy to ask the government to wait, but I think it's much, much harder to ask families who have endured unimaginable suffering, including forces families, at the hands of paramilitary violence, to continue to wait while time marches on. As we know, many of them are elderly. They've been waiting a very long time for answers, and in my view, and in the government's view, we should make these repeals as early as possible through the remedial order, so we have a legal framework that is fair, just and compliant with human rights. I have described it, and I will do so again, as a down payment on trust ahead of the Troubles Bill. And that is why I'm firmly of the view that the government has compelling reasons for proceeding with this order. Even more importantly, this is also the view of the Joint Committee on Human Rights, to whom I am grateful for their diligent consideration of this matter. Well, since it is the honourable member, my honourable friend, I will give way one last time.
Madam Deputy Speaker, can I thank the Secretary of State? On the point of trust, just so we get it on record, is there any guarantee that the Republic of Ireland will withdraw the interstate case once this passes, if this passes?
Well, the basis of the Republic of Ireland's matter for them, interstate case, is that the last government's if you just let me answer the question, I will do my best to respond, was that the last government's Legacy Act was incompatible with the European Convention on Human Rights. It is correct in advancing that argument because the courts in Northern Ireland have found the last government's Legacy Act to be incompatible in a number of respects. And my job, the government's job, is to make sure that the legislation is made compatible so that everyone in Northern Ireland can have confidence in the framework we are trying to put in place with as much support as possible. And at that moment, there is no basis for the interstate case anymore. It's a matter for the Irish government as to what they do with it, but it will have no basis and it will not be able to go anywhere because the House of Commons and the other place will have remedied the incompatibilities. And I'm grateful to the Joint Committee on Human Rights for their diligent consideration of this matter, and they've been clear. They've been clear. Well, how could I resist?
Ask the Secretary of State to acknowledge that it was not a unanimous opinion.
I was not about to advance the argument that it was a unanimous decision, but many a piece of legislation, many a report of a committee in this House and its history has been passed on a majority vote. That is how we reach decisions. And the JCHR couldn't have been clearer in its second report, recognising the unique and delicate circumstances surrounding Northern Ireland legacy matters, and I quote, it said, "The government has sufficiently compelling reasons to proceed by way of remedial order. The committee has recommended that this order be approved by both Houses of Parliament, and I urge the House to heed that recommendation by voting for the order tonight."
The question is as on the order paper. Shadow Secretary of State Alex Burghart.
Thank you very much, Madam Deputy Speaker. It's an honour and a privilege to be able to speak in this important debate. And it's particularly important because I know that there are some people watching this afternoon who themselves were on the line of action in what was surely one of the most difficult operations that British Armed Forces ever had to deploy. I know that some veterans are with us today in the House, and some of them are sitting on these green benches. And I think one of the things that all members have a duty to keep in their minds throughout this debate is our responsibility to them, the people who ultimately enabled peace to happen in Northern Ireland.
Hear, hear.
We are obviously opposed to the government's approach, and we've discussed this at a number of parliamentary events now. We think that the government has options that it is not taking, and that it is compromising both the peace of mind of veterans, but also endangering our military capability into the future. I noticed in the Times today an important letter from some retired SAS officers who said, peace requires compromise, restraint, and the decision to stop refighting the past. And the legislation that the previous government brought in was specifically designed to try and draw a line under all of the events that had happened, not so that there would not be information provided to families and victims, because ICRA enabled that to happen, but so we could move on from a new phase of the Troubles conflict, which was being fought in the courts. What we have now, and what we are debating today, we'll obviously have a chance to go through in greater detail when the legislation returns to the House for Committee of the Whole House. But the government's remedial order that we're debating now, which seeks to delete parts of the 23 Legacy Act, following the ruling of the Belfast Court of Appeal last year, means that the government says that it has no choice but to act as it has no choice but to try and change the legislation by means of remedial order. But we don't believe that that's the whole story, because, of course, when the government came to power, it had the option of appealing that decision that was made in the Court of Appeal in Belfast. Yeah, we know that they did, because the previous Conservative administration had received legal advice saying that not only was a legal challenge possible, a legal challenge had a high chance of success. Indeed, there were many experts outside of this House, legal experts outside of this House, in think tanks such as Policy Exchange, who set out why that might be the case. The government has implied two reasons why it dropped its appeal. The Secretary of State said in the House today, I think, and also on the 17th of December, that he believed that there was a moral outrage at the idea of immunity, and that there was a need to respect human rights law. And on their own grounds, these are respectable positions, but they're also clearly not quite true. In the first instance, the human rights argument can't stand on its own merits because there were grounds to appeal, and the government chose not to. So the government never found out what the actual position on human rights might have been if it had gone to the highest court in the land. But also, on the idea that immunity is a moral outrage, I fear that the Labour Party is being, at best, disingenuous. And I say this because the Secretary of State and other Labour members often refer to the immunity that was in our Act. Well, there was immunity, but it was conditional immunity.
That's the point.
It was immunity that was conditional on people giving up information to ICRA. And this was not a novel concept. Indeed, this was a concept which was what part of the cornerstone of the legislation introduced after 1998. There are plenty of examples. For the decommissioning of weapons legislation, which actively allowed for the destruction of forensic evidence which could have led to prosecutions. The victims' remains legislation, which allowed people to come forward and tell the authorities where victims were buried without fear of prosecution, what we might call immunity in return for information. The letters of comfort, which have already been discussed. There can be no doubt that John Downey effectively received immunity for the Hyde Park bombing case by dint of of his letter of comfort.
Yes.
And so with the royal prerogatives of mercy, and so, most significantly of all, with the 2005 legislation that Peter Hayne, now Lord Hayne, then Secretary of State, brought to this House, the Northern Ireland Defences Bill, which explicitly created, or would have created had it been passed, immunity for terrorists. Terrorists. Not for everyone, for terrorists. And it was only when, under pressure from families and the Conservative Party, that the government agreed to bring veterans into that legislation, that it was dropped because Sinn Féin ceased to support it.
Correct.
And I say this respectfully because the Secretary of State, the now Secretary of State, was in the Cabinet at the time and would have been bound by collective responsibility on this issue.
I'm grateful for the Honourable giving way. In essence, what he's talking about here with the agreements, the destruction of weaponry and the loss, therefore, of any ability to prosecute or proceed, was in a way one way, because there is no way on earth the same process was allowed for soldiers that had served in Northern Ireland, as all evidence was kept, captured and can be used against them, whereas the weaponry that was destroyed and all other matters such as letters of comfort tended in one direction on this. So when the government talks about equivalence, they're wrong. It has never been about equivalence, it's been about one-way traffic.
My right honourable friend could not be more correct. It has always been one-way traffic. And whenever this side of the House, whenever the Conservative Party has tried to create equivalence for veterans, the Labour Party has backed down. And that was something that we saw in the case of 2005, and I'm afraid that it's something we're seeing now, because when we introduced conditional immunity for veterans in the same way that conditional immunity had been used time and time again after 1998, the Labour Party opposed us.
They did.
An incredibly selective memory over the issue of conditional immunity. And on my right honourable friend's point about the unlevel playing field, I was discussing this with my honourable friend Lord Kane, who served the Northern Ireland Brief for very many years, who reminded me last night that in 1992, the IRA bombed the major forensic lab in Belfast, one of the largest bombs ever planted, £3,000 bomb, damaged about 1,000 houses, and it absolutely obliterated an enormous amount of forensic evidence that was kept on the IRA. And to that extent, the IRA gave itself a form of immunity by destroying evidence in a way that the British state never would have done. So we have to ask ourselves, why did the government really drop its appeal? And the Secretary of State says it was because of immunity. I'm afraid I can't believe that, because the Labour Party supported immunity in the past. And he says it's because of a lack of support for our legislation in Northern Ireland. And it's true. There was certainly not cross-party support for our legislation in Northern Ireland. But I hate to break it to the Secretary of State, but there is not party support for his legislation in Northern Ireland either.
Correct.
And if this is the case, it's really the case, then I'm not sure that the Secretary of State should be proceeding with what he's doing. And I'm afraid that leads me to... Very happy to give way to my right.
The Secretary of State frequently, he tells the truth, frequently says that the parties in Northern Ireland didn't support the legacy legislation. Now, I'm speaking from memory, so these numbers are approximate. But when there was a poll of the population of Northern Ireland, there was 30-something% were in favour of the legacy legislation and about 20-something% against, about 3-2. So if he's picking on popularity, on community support, he's in the wrong.
Dangerous territory.
Well, my right honourable friend has always had a very good head for what's popular, and I will check his figures, but I'm sure that they're correct. It's a very important point. We cannot pretend there was no support for what we were doing in Northern Ireland, because there are plenty of people in Northern Ireland who would like to move on. Yeah. There are plenty of people who respect the decision to draw a line and move on. I'm very happy to give way to the honourable gentleman.
Point, and we can talk about political parties, we can talk about the general population. Does the Shadow Secretary of State agree that there's nearly universal opposition amongst victims of terrorism on the condition of immunity in the previous Legacy Act?
No, I don't acknowledge that, because I've met victims and I've met people whose families were heavily affected by terrorism who supported our legislation. So I'm afraid I can't agree with him on that. I would certainly allow. Right honourable friend.
It's often said, and rightly, that what is very important is that families should find out the truth about what happened.
The key.
Which scenario makes it more likely that families will get the truth after all this time? Is it a scenario where people can be prosecuted on either side and therefore have an incentive, if they're guilty, to conceal the truth? Or is it a scenario such as existed under the legislation that our government brought in, whereby people are much encouraged to tell the truth about what happened because they know they will not be punished if they do so?
My right honourable friend has very succinctly summarised the central argument behind the Legacy Act 2023. That drawing a line does not mean covering up the past. Drawing a line was an opportunity to open the past in the way the adversarial system was never going to allow. And incidentally, in which I do not believe the adversarial system is going to bring justice for very many people at all. Because we must remember, Madam Deputy Speaker, that the peace process concluded in 1998, which is 28 years ago. And the Troubles, by most reckonings, deemed to have started in 1966, which is 60 years ago. And we have recently seen the case of Soldier F, where one of the longest public inquiries in British legal history presented the most forensic evidence that could be imagined. But the court was unable to reach a conclusion. And this means that the chances really of any prosecution coming to a conclusion are very, very limited. But that doesn't matter, because for many veterans, it is the process that is the punishment. It is the fact that, as we saw in October last year, when a former SAS veteran who was being accused of having behaved wrongly in 1991 was dragged through the courts, and eventually the court in Belfast said, and I quote the judge, the case against him was ludicrous, that it should never have come anywhere near him, but not after that individual hadn't been pursued for 4 years. And there are many such cases. And if the process is the punishment, then the fear of the process is a punishment for so many people who... I will give way to my right honourable friend.
My right honourable friend makes, again, a very good point on that specific case, but that judge also criticised the allocation of legal aid for that case. He said he could not understand how legal aid was given for such a futile case. But isn't this also a problem in Northern Ireland, that the legal aid rules there drive a machine which harms our soldiers?
Again, I have to agree with my right honourable gentleman. There is, in some quarters, an industry which I fear is allowing victims to believe that their chances of success are far greater than they are in practice. And this is, this is not pleasant. So we have to ask ourselves, why did the government drop its appeal?
On that point,
I will give way to my honourable.
I'm very grateful to my honourable friend for giving way on that point, as well as the self-licking lollipop of legislation and compensation. Does he also acknowledge that this is a proxy war? This is all about relitigating the question, who won?
Yes.
And we are allowing our brave servicemen and women who served the nation incredibly bravely in Northern Ireland to be used as pawns in a dreadful, awful proxy game to relitigate the question, who won? Does he agree with that?
I entirely agree with my honourable friend, who I know has great experience of these matters. The truth is that this is, for some people, this is the continuation of the Troubles by other means. Yes. And it is time to draw a line. So if the government was not withdrawing its appeal because of conditional immunity, because it supported conditional immunity in the past, if it was not really refusing to appeal because of views in Northern Ireland, given views in Northern Ireland of its own legislation, it must be for another reason. And I don't know what that reason is, and I don't suspect we will ever know. But I do wonder whether it is connected with the desire of this government to have close relationships with the Irish government as part of the European reset. I am happy to give way.
Surely we are regrettably here, Shadow Minister, because of our membership of a foreign court. And without our membership of the ECHR, we would not be in this mess, would not be having this debate, and we could be moving on towards truth and reconciliation.
Well, then that's exactly one of the reasons why the next Conservative government will leave the European Convention on Human Rights. It is, and I will give way to my Right Honourable
The Human Rights Act 1998 does not require the government to take any action as a consequence of the decisions that were made in the courts. It's entirely a matter for this House. The government has made a choice, and the government had a choice to pursue the remedial order through primary legislation or through this remedial order. It made a choice, notwithstanding the fact that it's got a bill coming down the line. Frankly, I think that was a ridiculous decision by my committee, but there it is.
I believe that we almost got a sort of scintilla of insight into how my right honourable friend feels about the latest Joint Committee on Human Rights report. I'm grateful to him for preempting some of what I'm about to say. But I do worry that there is a bigger game going on in government. You know, my honourable friend said that veterans are being used as a pawn in lawfare. But I wonder whether the case against veterans is also being used as a pawn in a bigger game that the government is playing with the European Union. The Secretary of State then says he has no choice. But of course, His Majesty's government does have a choice, has options. The first option it had was to appeal. It did not. Its second option it now has is, of course, to wait, because the Northern Ireland Veterans Movement on the 15th of October last year was Lord Wolfson, KC, who represents them, Right Honourable Lord Wolfson, KC, who represents them pro bono. He was heard by the court and allowed to give oral and written evidence, which the court is now considering. And it is perfectly within the scope of what the UK Supreme Court might say, that it might find that elements of the Legacy Act are actually not incompatible with the European Convention on Human Rights. But if the Secretary of State's remedial order has gone through both houses by that time, we will be presented with legal chaos. Yes. Because the government will have used an order that it had no authority to use in order to remove primary legislation which should actually still be in place. And the government can avoid this. All the government need do is wait and see what the Supreme Court says. And the Secretary of State, in fairness, he thinks he knows what the Supreme Court will say. But I'm not sure that he does in reality. And so he has an option. Third, I will give way quickly.
I hope I'm not misquoting the Secretary of State, but he said, I think, the reason why they're using this guillotine motion today to withdraw parts of an existing law before they have another one in place was because of urgency, and that the urgency was created by a desire to build trust in both the victims, civilian victims of terrorism and the military victims of terrorism. He seemed to miss out one group in that building of trust, and that was the military veterans, who will also come under consideration if he drops the guillotine on the existing Act today.
Yes. Once again, my honourable friend is quite right, because if the remedial order goes through both houses and the Supreme Court has not opined, then from that moment, from the next day, civil cases will reopen and military veterans will be involved in that action. And I would be delighted to give way to my right honourable friend.
It seems to me that what the Secretary of State is doing is adopting a highly technical and extremely unmeritorious argument. He says that because the declaration of incompatibility is not the subject of the intervention of the veterans, it gives him the opportunity, entirely technically and devoid of any moral merit whatsoever, to bring this remedial order. But he knows perfectly well that the substance of the argument on which the remedial order is based is very much in point in the deliberations of the Supreme Court. And so what they would do, if they decided against him, is to remove the entire basis for the remedial order he's bringing. Yes. But because technically he can bring it, he's decided to do so. Yes, exactly. That's not like the Secretary of State. That's not like the Secretary of State.
Well, I'm delighted to have had the support of my right honourable friend on a matter of pure legal substance. And very learned friend. And that the truth is that if one looks back at the debates on the Human Rights Act, that the purpose of Section 10 is to make sure that the government cannot use remedial orders. It's an incredibly powerful tool, a remedial order. A statutory instrument that can strike down primary legislation cannot use this incredibly powerful instrument unless the case is fully decided. In this case, it clearly isn't. In this case, it is open. And that is why this government is acting ultra vires. And I return briefly to the remarks made by my right honourable friend behind me, who represents the New Forest, west part, the best part of the New Forest. The joint first best place in the New Forest. The Secretary of State has invoked the Joint Committee. But it is my understanding that the Joint Committee, when it wrote its report, was unaware that the Northern Ireland veterans movement was being heard in the Supreme Court. Yes. And I rather think that that might have had a profound effect on what they wrote. I'm happy to give way.
I am also a member of the Human Rights Committee, and whilst I, of course, cannot respond directly to the claim that the honourable gentleman has just made, because that would be breaching parliamentary privilege, and I would not want to do so. I will simply put on record that our committee considered all the relevant evidence when we created not just our second report on this remedial order, but our first two. We considered all of the evidence in front of us, we made our report, and we stand by both of those reports.
I'm not doubting that the committee examined all the evidence it had available to it. What I'm disputing is what evidence it had available to it. What we're faced with is a situation in which the government doesn't really have a legal basis for what it's doing, it doesn't have a moral basis for what it's doing, and there are real-life consequences to the decisions it is making. I'd be delighted to give way to my honourable friend.
Would they also consider that there's the political reason for the Northern Ireland office to bring this forward, and that's to placate the Irish government and their timeline rather than the timeline of this place?
I suspect very strongly that my honourable friend is right. I suspect that this is bound up in the agreement that the Secretary of State made with the Irish government, but he can correct that later on. If he wishes to, but I have to say that there were some things in that agreement that I welcomed at the time and I welcome again now. If it leads to the Irish government opening its books and being clear about collusion between the Garda and the Provisional IRA, then I would welcome that. But something I can't welcome is the fact that there was an opportunity in that agreement to ask the Republic of Ireland to open its own inquiry into the Omagh bombing. And this is something that was recommended at the time, and the British government recommended to the British government that we should have our own full inquiry, but it was deemed to be pretty much a necessity that a similar inquiry was conducted on the other side of the border so that there was the opportunity to compel witnesses to give evidence under oath about what was known and what, if any, collusion took place. And I'm very sorry that that opportunity was missed. Happily give way to the Honourable Lady.
Many of those supporting the Oma families would like to see a parallel and a comprehensive inquiry. Would the member agree with me that the logical thing to do would have been to co-design that and for both governments to bring forward inquiries in parallel rather than his government acting unilaterally when they announced theirs?
I would have been very open to that idea, but I believe that the previous administration did not feel that there was the opportunity to proceed in that way. But look, what the Honourable Lady, if we were thinking about things for the future, I think what the Honourable Lady proposes is a perfectly sensible idea. I give way to my honourable friend from Strangford.
Giving way. The reason that we don't trust the Irish government on legacy issues is clear and is warned. It was a murder haven for years. Many people who committed murders, and we know, hopefully we'll explain some of them later on, but they escaped across the border. And when we look at the government, if we're going to rebuild bridges without the honesty of the state collusion with IRA terrorists and the Irish government, quite clearly their hands are dirty. And when it comes to this bill, then I want to see the Republic of Ireland government and their ministers and the Garda Síochána officers getting the same accountability in the process. My constituents have never had justice. I want to see justice for them.
Would he give way on that point?
I will, if my right honourable friend will allow me, I may respond to that intervention briefly and then allow him to supplement my answer. My honourable friend from Strangford has very deep personal and professional experience of this matter. And of course he is right that just as the inquiry into the truth has been one-sided within the United Kingdom, it is also, I think, for large periods, been unequal without it as well. I give way to my right honourable friend.
Honourable friend's comments tie directly into the Honourable Lady's comments, because in the Omagh bombing, the bomb was constructed in Ireland, the detonator was made at their factory, in effect, in Ireland, the car came from Ireland, and they disappeared back into Ireland afterwards. And there is a suggestion that the Irish Special Branch knew a great deal about it before it actually happened. So there's very good reason why the Irish government doesn't want to have an inquiry into its part in this matter.
Well, indeed, these are all things that I know we would all love to get to the bottom of. And so look, as I draw my remarks to a close, Madam Deputy Speaker, I'd say to Labour backbenchers who are considering how they might vote, not just this evening, but also when we get to the bill proper. This doesn't have to be done in this way. Happy to give way to the Chair of the Select Committee.
I thank the Shadow Secretary of State for giving way, and I'd like to make the point that a lot of work is done in good faith in this House, particularly on my Select Committee, particularly by the Secretary of State. And I really do not appreciate the way in which this debate is being led on the benches opposite, and I think he should take a while to look through the recommendations of the Troubles work that we have done as a committee and take it seriously and have productive conversations on how to move this forward.
I take everything the Honourable Ladies Committee does incredibly seriously. There's a good deal of experience on there, and she always has interesting witnesses. Very interested in the remarks made her committee the other day by experts in Police Service Northern Ireland. I hope to have the opportunity to talk to her about that, as well as to the people who were giving evidence. But I'm afraid this doesn't. None of that takes away from the fact that there is a choice before this House. We do not have to go down this route of erasing the line that has been we have attempted to draw under the Troubles. And I say to honourable members opposite, there is not just a moral risk in this, there is also a political risk for anyone who has doubts, because it is simply put, the Prime Minister has, over the course of the past few months, U-turned, I'd say, is it 12 or 13 times? 14 times. I lose track. And I believe that there is every possibility that just as there was a U-turn 24 hours ago on social media for young people because of representations that were made, I believe, from 60 members of the Labour backbench, so there is the opportunity to stop the government in its tracks on this incredibly serious issue. I will give way to one more time to my honourable.
I'm incredibly grateful to the Shadow Secretary of State for giving way on that point. He makes a very powerful point, but I think it's worth putting on the record that it's pretty unlikely that his words will carry the day on the basis that there are 8 Labour backbenchers here to hear this sort of debate about applying a guillotine to gut a piece of existing legislation without putting anything else in place.
No, I'm very pleased my honourable friend had the opportunity to put that on the record, that there sadly are not many members of the Labour backbench here to hear it. And I wish there were, because, as I say, there is an alternative. And I know I will give way. No, I will not give way. I do believe that if the Labour backbench was to mount significant pressure in private, the government would think again. The government would think again. And if they did, it would create the opportunity once again for many of our brave veterans from Operation Banner to be able to sleep peacefully at night. So, Madam Deputy Speaker, as I draw my remarks to a close, I remind all honourable members to be mindful of the past and the future. The Conservatives sought to draw a line. This government is erasing that line, and in so doing is dredging up the past in a way that will allow the troubles to be fought again and again in the courtroom. This continuation of the conflict by other means, by legal means, ultimately undermines and reduces the opportunity that we have for reconciliation. It also undeniably comes at an operational cost. We know this because those people who know most about military operations tell us it is so. General Sir Nick Parker and General Sir Peter Wall, both of whom have served our country at the very highest levels, write today in the Telegraph, those currently serving, particularly in operations where judgment is exercised under extreme pressure, are watching closely. If lawful decisions taken in good faith can be re-examined endlessly, decades later, confidence in command, willingness to serve, and trust in political backing inevitably suffer. Enemies and allies notice this as well. Let us remember the General's words.
Andy McDonald.
Madam Deputy Speaker, I welcome the introduction of the remedial order. It is a necessary and overdue step if this government is to retain the confidence of the people of Northern Ireland that it is serious about justice, accountability and dealing honestly with the legacy of the Troubles. As several gallant and honourable members have said from these benches, they never wanted special protection, exemptions or immunity from the law. They wanted and expected exactly what the public expects, to be judged by the same universal standards of justice that apply to everyone else. Accountability does not weaken the armed forces, it strengthens trust in them. The remedial order recognises this basic principle. It removes the conditional immunity, the de facto amnesty contained in the 2023 Legacy Act, provisions that were found unlawful by the courts in the Dillon case in Belfast. The High Court and the Court of Appeal were clear that those provisions breached Articles 2 and 3 of the European Convention on Human Rights and the Windsor Framework. The government accepted that judgment and rightly abandoned its appeal. These immunity provisions never legally took effect. and it is right that they are now formally removed. The order also restores access to civil claims, reopening an important route to truth and accountability that had been wrongly closed. These processes were never about witch hunts. Since the Good Friday Agreement, only one former soldier has been convicted for a Troubles-era killing, and he received a suspended sentence. That is not lawfare. What civil cases and inquests have done is correct false records, expose wrongdoing, and finally give families truthful answers after decades of official denial. However, we must be honest, the Remedial Order does not go far enough. Section 45 of the Legacy Act, which blocks the Police Ombudsman for Northern Ireland from investigating Troubles-related police misconduct, remains unaddressed. The Court of Appeal found this to be incompatible with human rights, yet victims and families are still denied access to a fully independent investigative mechanism. That failure continues. The government is, of course, serious about a victim-centred approach to the past, but in pursuit of that, further amendments are essential. National security must not be used as a smokescreen for secrecy. Families must have enforceable rights to truth, information and challenge, particularly where the Secretary of State retains wide powers over legacy bodies. This is especially important given the unresolved disagreements surrounding the Public Office Accountability Bill. I'll happily give away.
To the honourable member for giving way, I'm new in this place, but my sense of him is that he's a great parliamentarian. And so I would just like to understand how he has reconciled himself with the government bringing in a remedial order whereby we're pulling a law out before we put a new one in. How has he reconciled himself that that is the correct course to take?
Well, I thank the honourable member for that intervention. But of course, there is an obligation upon this government under the Human Rights Act where it deems, where it has been told by a court that there's legislation that's incompatible with the convention right under Section 4 of the Human Rights Act, they're duty bound and have the ability to make that, to remove that incompatibility. And that is exactly what is being done here. So, well, I'm afraid that's the honourable member turns from a sedentary position, but that is actually the legal position. But in closing, Madam Deputy Speaker, the remedial order is a positive correction, but it's only a first step. Justice delayed has already cost families decades. Justice diluted will cost confidence altogether. If we want reconciliation rooted in truth, the law must apply equally to all, and independent investigations must be fully restored. Thank you.
Liberal Democrat spokesperson Paul Kohler.
Thank you, Madam Deputy Speaker. I've listened carefully to those who have spoken before me, and while there are clear differences across the House, I hope there's a shared recognition of the gravity of the issues we are debating, the responsibility that rests on Parliament to approach them with care. I'll begin, as I have done previously on this matter, by recognising the deep, enduring scars left by the Troubles. For victims, survivors, veterans, families and communities across Northern Ireland and beyond. The issues we are considering reflect lived experience and demand seriousness and humility, not grandstanding. But that does not preclude, in fact requires us making clear the Conservative Legacy Act was a failure. It failed victims, it failed survivors and it failed veterans. It's not the opinion of the Liberal Democrats, it's the view of every major party in Northern Ireland, victims' organisations, the vast majority of veterans I have met and ultimately the courts. The Northern Ireland Court of Appeal was clear in 2024 that core provisions of the Act were incompatible with the European Convention on Human Rights. Parliament cannot simply shrug its shoulders at that judgment, and there is no more apposite time than now to confirm we are a country governed by the rule of law, not by wishful thinking or culture war rhetoric. For that reason, Liberal Democrats welcome this remedial order. And can I remind this House, there are a greater percentage of veterans in my parliamentary party than any other party in this House. A gallant cohort who will agree to nothing that will let down our veterans and believe the remedial order is necessary, because it removes the most egregious provisions of the Act, including immunity that extended to terrorists and bars on civil actions. Those measures were corrosive to trust, creating an abhorrent moral equivalence between those who serve the state and those who sought to destroy it. This remedial order must consequently be seen as a prerequisite to any credible legacy process, not as a concession to apologists and terrorists. That is why it's difficult to understand those who argue this House should vote against the remedial order. To do so would be to defend legislation that courts have ruled unlawful, to prolong uncertainty for victims and veterans alike. It would leave us knowingly in breach of our international obligations and further undermine confidence in the institutions tasked with dealing with the past. That is simply wrong, both as a matter of principle and in practice. And to those who argue the remedial order should be delayed until judgment in Dillon is handed down, I would simply concur with the Secretary of State. Put simply, notwithstanding paragraph 710 of the Court of Appeal judgment, the declaration of incompatibility will remain whether or not the government wins its appeal on Article 2 of the Windsor Framework. Now, while the Secretary of State will doubtless welcome our support, I do not wish to lull him to a false sense of security. Welcoming the remedial order does not mean declaring the job done. There remain serious deficiencies in the forthcoming Troubles Bill that must be addressed if any new framework is to command confidence across communities. That is why my party has tabled constructive amendments and new clauses, not to wreck the legislation but to save it. In particular, we remain deeply concerned about protections for veterans. Veterans are not asking for immunity. They tell me repeatedly they don't want immunity. They're asking for fairness, proportionality, and into the fear that the process of investigation becomes an instrument of persecution. I will.
I'm grateful to the Liberal Democrat spokesman for giving way. I fear he may have misspoken earlier on in his remarks, and I'm just going to quote from the Joint Committee on Human Rights report on the first draft. A declaration of incompatibility has no legal effect and does not affect the ongoing validity of the incompatible legislation. It is merely a tool by which the courts can draw attention to an incompatibility. It is then for the government and the Parliament to decide what action, if any, it takes.
Just said otherwise, and it's for our government to stand up for our international obligations. Look about you. Look what's happening at the moment with Greenland. This is the time when we should stand up for our international obligations. This time we believe in the rule of law. There's a declaration of incompatibility, and we as a government should absolutely stand up for our international obligations.
The point my honourable friend, my honourable and gallant friend made relates directly back to the Human Rights Act. That is the law in this country.
Thank you.
And I think that intervention, and the government has a choice to make to stand up for our international obligations. That is the right thing to do. That is surely the right thing to do. At this time of all time, surely we should stand up for international obligations. Our amendments seek to put clear statute definitions in place to strengthen safeguards against disproportionate legal action, to provide a presumption of remote participation, to protect anonymity, to establish independent oversight of how those safeguards operate in practice. Our approaches are about recognising service, context and the cumulative impact of decades of investigation, not about shielding wrongdoing. The Liberal Democrats also recognise that reconciliation cannot be achieved by legal mechanisms alone. If we ask,
I've seen a pattern for me. I thank the honourable member for giving way, but I hope he didn't misquote where he said that the Liberal Democrats had more veterans in their parliamentary party than anyone else, where they have 8 and we have 17. And I do only see that I believe one of yours is here today when many of ours are here.
Thank you for that intervention. We have a greater percentage, I think you'll find, and it's more. Well, I did say that. I did say that.
So where are they all?
I'm sorry, I did say that.
So where are they all?
You know, these are the words. Listen to what I said is what I'd say to you.
So where are they?
The Liberal Democrats all it now. No, let's look at this. We need more gravity in the House than this. There's grandstanding, the jocularity, the jokes. This is not the way to approach a serious situation. No, I will not give in. I'm not. Now it's just grandstanding, and I'm not going to give in to more grandstanding.
Order. Please sit down. The temperature just needs to be lowered to allow the honourable gentleman to deliver his remarks. Paul Kohler.
If we are serious about moving towards a shared and stable future for Northern Ireland, legacy process must be connected to a broader reconciliation strategy. That is why we have proposed a statutory duty on the Secretary of State to publish such a strategy, developed in consultation with victims, institutions and Parliament. Addressing the past and building the future must go hand in hand. Finally, a word about the European Convention on Human Rights. This remedial order arises precisely because the ECHR compliance matters. The Good Friday Agreement is built on it, and as such, peace in Northern Ireland depends on it. Those who casually call for withdrawal are playing fast and loose with our history, our rights, our futures, and our very union. We will support this remedial order, oppose those who would block it for self-serving reasons, and continue to work constructively with members from across the House to fashion an appropriate legacy process. Thank you.
I call Peter Swallow.
Thank you, Madam Deputy Speaker, and I felt it important to speak on this debate today as a member of the Joint Committee on Human Rights. I'll acknowledge, of course, that we, until recently, had another member in the House from that committee, the Honourable Member for New Forest West. When he came over to speak to me just now, I was slightly worried he was defecting, but I am assured that he was just, in fact, letting me know that, unfortunately, he wasn't able to stay for the rest of the debate. But I did want to just start by acknowledging that there were differences of opinion as he set out on this important issue. But nevertheless, the committee carried out its constitutional role to scrutinise this remedial order. As the standing orders of both houses set out, we must. As we're mandated to do, the JCHR has produced 2 reports on the remedial order concerned today and has been clear and unambiguous in its recommendation that this remedial order be approved by the House. I should emphasise that the focus of the reports was on the remedial order in front of us today, not the bill, and I'll similarly focus my remarks squarely on the order. As my right honourable friend, the Secretary of State, has set out, this remedial order follows rulings by the High Court of Northern Ireland and the Court of Appeal that declared a number of provisions within the previous government's Legacy Act to be incompatible with our human rights obligations under the ECHR. The Legacy Act prohibited any criminal investigations into troubles-related offence being initiated or continued, prohibited any criminal enforcement action in relation to non-serious troubles-related offences, ended troubles-related civil claims which began after the Legacy Act's first reading, and prohibited new ones, and obliged the Independent Commission for Reconciliation and Information Recovery to give immunity from prosecution where certain conditions were met. And yes, this extended to giving immunity from prosecution to terrorists. The Legacy Act was a deeply flawed piece of legislation, a fact which has been reflected in the Court's rulings on its incompatibilities with our human rights legislation. This order, alongside the bill, seeks to remedy these incompatibilities. Of course.
He says this order alongside that bill, and I am actually very grateful to the Joint Committee on Human Rights on which he sits for producing this report. I think it's very, very good. But I would like to try and get a question, which I didn't get earlier, to how the honourable member reconciles the fact that this remedial order is being used as a guillotine to gut an existing piece of legislation before his government has put something else in place. How's he reconciled with that?
I'm very happy to jump forward in my speech to address the issue that the honourable member raises. What I would just gently say to start with, however, is that by removing incompatibilities which courts have put in legal limbo, this government is quite rightly acting to correct those incompatibilities. That is good governance, not bad. Let me address the point more specifically. To say that it is unusual for any government to introduce a remedial order and a bill, both addressing incompatibilities on the same day, would be an understatement. And the committee's long-held view is that primary legislation is always preferable to address incompatibilities where that is available, a view re-emphasised in our second report. But, and this is important, we also recognise the unique complexities and sensitivities of this issue. And for that reason, our recommendation was that this remedial order be approved. I want to acknowledge that it is an unusual remedial order in that it's being presented at the same time, as I've said, as a bill. And I do welcome the bill as well, the bill before the House. Unlike the Legacy Act introduced by the last government, this is a bill which does not give immunity to terrorists and recognises the rights of communities to access the justice our legal framework affords to all. It also produces important safeguards for veterans, including protection from repeated investigations, the right to seek anonymity, the right not to be forced to travel to give evidence, protection in old age, and protection from cold calling or unexpected letters. Importantly, these safeguards also include a right for veterans' voices to be heard through the inclusion of veterans' representatives in the statutory Victims and Survivors Advisory Group. These measures strike the balance between protecting those who serve to keep the peace and protect life and ensuring that terrorist acts are not granted immunity. Of course.
I'm grateful to the honourable member for giving way, who's describing the bill. We're not here to debate the bill. We're here to debate the remedial order. And I asked him why he got comfortable with the fact that we're not, we're guillotining a piece of law without putting something in place. And he hasn't answered that yet. And he's answered that they can. He hasn't answered why they should.
As the report sets out, the government set forward its reasons for proceeding with the remedial order alongside a bill, and the Secretary of State has shared those reasons today. It always befalls a government where an incompatibility has been identified to choose the manner in which to address it. There are four options. The first option is to do nothing, which of course we very well could have done, but as the Liberal Democrat spokesperson eloquently pointed out, would not see us complying with our international obligations, and that's not something I would feel comfortable with. The second would be to introduce a remedial order which had to be approved as an urgent remedial order. He'll forgive me if I don't remember the precise language on my feet, but there is a route for a more rapid remedial order. That's not the route the government decided to go down, and I welcome that as well, because I think it is important that we have the time to properly scrutinise anything on this most sensitive issue. The third option is the option the government has taken, and the fourth is, of course, to deal with it solely in primary legislation. As the Secretary of State set out, and he was very forthcoming in appearing before the committee and also providing additional correspondence to us as well, the decision that he took was that the appropriate route was to address this with a remedial order, and he did that because it was important to build trust in communities across Northern Ireland by more swiftly addressing the incompatibilities that have been identified. I hope that fulsome response has addressed the honourable gentleman's concerns, and I can continue with my speech. Fantastic, thank you. My right honourable friend has been clear that he recognises that this is a sensitive bill which seeks to address not only the lasting legacy of a highly emotive and contested period of our history, but also the enduring lived reality of what that legacy means for communities across Northern Ireland and the whole of the UK. For this reason, the government has set out its grounds for seeking to use a remedial order. I refer to that in great detail. I will also just emphasise that, given the nature of the bill before the House, it will be the case that the legislation will take some time to progress as it's scrutinised by both Houses and indeed will undergo scrutiny by our committee. That is, I think, Madam Deputy Speaker is indicating more than enough for me to set out the reasons why the Joint Committee on Human Rights recommended that this remedial order be approved. I end only to emphasise that as a member of the JCHR, I stand by the reports we have made, and our considered recommendation to approve is clear.
Members will have seen the interest in this debate shown by the number of members on their feet and will be aware of the short timescale that we've got. I would therefore ask that members, whilst I don't want to bring a time limit in at this moment, I would ask that members do keep their comments as brief as possible to help each other out. Sir David Davies.
Thank you, Madam Deputy Speaker. I suppose I should declare an interest. I was the only person, along with Tom Watson, to have had an Act of Parliament struck down in the courts, not using a declaration of incompatibility, but actually using article rights and so on. So I'm quite familiar with that process, and this is not it. Also, I say to the honourable gentleman who's just been speaking, I commend him for taking part in the JCHR. I think it's an incredibly important committee. I will say to him that mostly through its history, it has had unanimous judgment. Certainly when Harriet Harman, for example, was a brilliant chairman, it was almost entirely unanimous judgments. It was never on a party basis. Now, in order to make this side of the House very happy, I'm going to start by talking about the Human Rights Act. The Human Rights Act 1998 requires, quotes, compelling reasons to bring forward a remedial order with the Joint Committee on Human Rights, later clarifying that there is, and I quote, a general constitutional principle that it's desirable for amendments to primary legislation to be made by way of a bill, not by a remedial order. And although the JCHR allowed the progress of a remedial order, it was after significant amendment and by majority vote, not the usual unanimity, and with them stating, and I do recommend honourable friends and honourable colleagues read this, I quote, "It is highly unusual that the government has laid a bill and a remedial order concerning the same subject matter on the very same day. Usually we would consider the government's approach constitutionally improper." Right? I agree, and I do encourage colleagues to read this bill, this report, which my honourable friend was waving earlier, because you can almost see the discomfort in dealing with this. Now, what happened? In a moment. What happened was that the Secretary of State made an appeal on the basis of the urgency in his mind of this matter. And the honourable gentleman, which I'm going to give way to in a second, just referred to it, the honourable member for Bracknell, as unique in its complexity. Now, I say to all of the House, that's precisely a reason to use primary legislation, not a parliamentary technique which allows no amendment whatsoever. Because my arguments about this are arguments of detail that go to the interests of the people of Northern Ireland individually, not some sweeping order that takes away rights. I give way.
I'm grateful for the right honourable gentleman for referring to our report to advance his argument. I wonder if he could be as kind as to read the next sentence in our report.
I encourage everybody to read it. I'm not saying take my word for it. I'm saying read this report, because you can see the tension in the committee in reading the report. Now, of course, as the Secretary of State said, there are a number of real innocent victims who are seeking some sort of succour or recourse, which he's aiming to help. But he started out by talking about the huge number of people who are killed by paramilitaries in Northern Ireland. And I warrant that when this goes through, there will be a massive differential between those who were killed by paramilitaries and those who are asking for information. I give way.
The figures that the Secretary of State himself gave bear out the argument that the member is making. Of the 200 additional civil cases, 120 of them are directed towards the MOD. Does that not bear out the very point that the member is making, that this will be a one-sided outcome and a one-sided operation?
The honourable gentleman has got a long and honourable service in this area, and he's exactly right, and he understands, as everybody on this side does, well, most people on this side do, that there are asymmetries built into the system which handicap and indeed sometimes terrify the people on one side of the argument whilst favouring those on the other. And I want to talk to that because obviously, as we've heard, the new remedial order will allow new civil cases to be brought and, we're told, bring justice to victims. Well, government policy, as we've heard time and again, does not differentiate between real victims and terrorists. It will allow IRA sympathisers to continue their campaign of vexatious lawfare, hauling our brave veterans into court. Now, I'll remind the House, in 2006, the Blair government passed a law which said anyone hurt in the Troubles is classed as a victim. That means a proven murderer, a proven serial murderer, killed in the process of carrying out another murder is classed as a victim. Imagine it in the rest of the UK. Imagine a bank robber who's already a murderer and is shot trying to rob another bank. Do we think he's a victim? Now, that's out of the politics of Northern Ireland. But in Northern Ireland, classified as a victim. So when the Secretary of State talks about victims' families, he is actually, in many cases, referring to families of IRA terrorists. Now, frankly, if the government's legislation matched the government's rhetoric, the word victim would always be preceded by the word innocent. Yeah. If we're talking about innocent victims, I think many of the differences across this floor would evaporate. But that's not the truth. And indeed, the other side in this argument, Sinn Féin and IRA sympathisers, actually know this. The DUP proved this, actually, in September last year, when they attempted to put a motion in front of Stormont, actually putting innocent in front of the word victim. And it was voted down by Sinn Féin and their allies because they know they depend on this massive confusion of the rest of the world over what a victim really is. I'll give it.
The honourable member accept from me that one of the classic examples of what he's just saying was the Schenkel bomb, where the perpetrator of that bomb was an IRA terrorist, and he was killed along with the innocent people whom he murdered. And yet Sinn Féin and Republicans insist on trying to portray him as a victim as opposed to those that he genuinely caused to be victims.
Right. Of course, that's a part of what my honourable and gallant friend was describing earlier about trying to rewrite history. But you see, this comes right to the core of what the Secretary of State's already done in this, because we know he's promised Mayor Ed Kelly that there's going to be a coroner's inquest for Goole. Why? Because her brother, Patrick Kelly, was killed at Goole, a victim. Except he killed at least 5 other people previously, including 2 UDR officers. He and his gang of 8 were attempting to blow up, well, in fact, they did blow up the police station with soldiers and policemen inside, a 400-pound bomb. And they had heavy weapons, again, my honourable and gallant friend will recognise them, G36s, to shoot through the walls and kill policemen there. And you want to see a piece of rewriting of history? Kelly's family have already attempted to rewrite history, claiming that Goole he went to blow up, not to kill. Despite his long and bloody track record proving otherwise. And he's obviously designed a bomb that only hits bricks, not people. Now, I don't aim to make light of this because it is incredibly serious. And as we've heard with 120 actions, Kelly's family have already brought legal action against the Minister of Defence. And they're not the only one. Let's look at the other IRA terrorists, quotes, victims, who have brought civil cases. In 2011, Aidan McKeever, the getaway driver at the Clono incident in 1992, in which 4 IRA terrorists were killed, was awarded £75,000, sustained when fleeing the scene. He's not a victim, he's a terrorist. And he got £75,000. Remember, the IRA are trying to pretend that this was a killing operation. The SAS, or the soldiers on the scene, whoever they were, actually gave him first aid to save his life because he'd been shot and injured. And yet he gets £75,000 from the state. Yep. In 2023, the family of Stan Carberry tried to sue the Ministry of Defence for his death in 1972. Carberry was an IRA volunteer, and he was killed after a soldier returned fire at the vehicle that he was shooting from. So, forgive me, I really want to get to the end of this. And Jerry Adams, we know, was already preparing legal action, challenging the decision to prevent him and others from being compensated for being interned in the Troubles. The surviving IRA terrorists and their families will benefit from what we're doing today. There will be few, there will be some. The right honourable gentleman, the Secretary of State, actually mentioned some of them. Civil claims brought against IRA killers, but there'll be rather special circumstances. Omar is one of them. I could explain why, but we haven't got time. There will be a few, but there'll be very, very few compared with thousands of deaths, tortures and murders. And that's largely because Tony Blair and Jonathan Powell accepted as part of the Good Friday Agreement not to allow the decommissioned weapons to be studied for forensic purposes. Point one. They also precluded recovered bodies from being examined for forensic purposes. So those people who have had people murdered and the body's been recovered, they're not even allowed to use the bullets in them to see who killed them, you know, those families. So that's how this justice works. And of course there will be no witnesses to the IRA crimes. The IRA themselves will not give witness, and I'm afraid anybody else will be taking their lives in their hands. So I want to finish by saying this. Today's remedial order will allow the IRA to further their campaign of rewriting the history of the Troubles, portraying our brave soldiers as state-sponsored killers and falsely representing themselves as victims and heroes, neither of which is true.
Alex Ballinger.
Thank you, Madam Deputy Speaker, and I'm happy to speak today in support of this motion on the Northern Ireland Legacy Act remedial order. The wider context is straightforward. The Legacy Act passed by the Conservatives in 2023 attempted to replace long-standing legal routes with a new commission, ICRIR, and a conditional immunity scheme. That approach did not command support in Northern Ireland, and it did not withstand legal scrutiny. Both the High Court and the Belfast Court of Appeal found key provisions in the Act incompatible with UK human rights law, in particular where they undermined the state's duties to investigate serious harm and where the Act shut victims, including the victims of terrorist attacks, out of court. And this was entirely foreseeable, as the Joint Committee on Human Rights warned in 2022 at a time when there was a majority of Conservative politicians on the Joint Committee. They warned the government's approach risked widespread breaches of human rights law and would fail to meet minimum standards for effective investigations. Victims of the Troubles and their families, including British servicemen killed by terrorists, would have had their routes to justice shut down by the Conservatives' unlawful Legacy Act. Nevertheless, they pressed ahead regardless, passing an act they knew would never be compatible with UK law and therefore would never commence. False promises were made to our veterans, and negligence was dressed up as decisiveness. So it is right that the Labour government has committed to repeal and replace their failed act through primary legislation, but today is about a necessary interim step, the remedial order before the House. This remedial order exists to fix human rights breaches quickly when the courts have found that Parliament's work has cut across basic protections. So what does it actually do? First, it removes the Act's conditional immunity provisions, the quite outrageous provisions that allow terrorists to secure immunity from prosecution by offering an account to the best of their knowledge and belief. Those provisions were never enacted as they were struck down by the courts, but their presence on the statute book has done real damage. It has fuelled mistrust, created uncertainty, and offered a false promise of protection to veterans that could never be delivered. Second, it removes the statutory bar on Troubles-related civil claims. The 2023 Act sought to block citizens of the United Kingdom for pursuing justice for crimes that they have faced during the Troubles. I believe that was wrong in principle, and indeed it was found incompatible with Article 6 of the Convention. And thirdly, it removes the exclusion of protected material gathered by ICRIR from being used in civil proceedings and certain other processes. In plain English, this stops victims who would have had their hands tied by the law from using evidence they would need to seek justice. So, Madam Deputy Speaker, much of the opposition's rhetoric has been directed at veterans, and as a veteran myself, let me address that head on. There has never been and never will be any moral equivalence between our armed forces who serve to uphold law and order and terrorist organisations that targeted civilians. I will happily give way.
I'm grateful to my honourable and gallant friend for giving way. He's glossed over another thing that he's potentially going to walk through the voting lobby to do today, and that is going to be allow Jerry Adams to claim compensation because he was interned on the basis that was illegal, because the Secretary of State didn't sign his order, it was the Minister of State. So would he like to tell his veteran friends and tell the peoples of Halesowen why he's happy to walk through that voting lobby and to vote to give Jerry Adams that right?
Correct. And in fact, the Prime Minister, when asked this question a few weeks ago, said categorically we would not allow Jerry Adams to claim compensation. In fact, there are several civil cases that would be blocked supporting the victims of IRA terrorism, including a case involving Jerry Adams, that this remedial order will help go forward. So I think it's important that we look about and think about the victims of the appalling terrorist paramilitary crimes. I will give way.
I've been listening very carefully to what he has to say, and he's right to assert that there is no there should be no legal equivalence between the perpetrators of terror and those sent out to do the state's business in Northern Ireland. But can he understand the views of the great majority of veterans, many of whom I have the privilege to represent, that feels that what this government is doing is undermining and holding below the waterline legislation which, however imperfect and subject to an appeal, was going some way to giving them some comfort?
So I am a veteran, I speak to many veterans, and I think he will agree there are a range of views on this issue. Those of us who have served, we served to uphold the rule of law in whatever service that was. And I think it's beholden on us, and it's beholden on people that serve, that if they are upholding the rule of law, they're accountable to that rule of law. And I will say, Brigadier John Donnelly, who did serve in Northern Ireland and was chair of the Centre for Military Justice, currently chair, he said, you cannot have a system of law that applies to some groups and not to others. It is vital that soldiers operating in support of the civil powers are held fully accountable for the laws they are required to enforce. That is the difference between the soldier and the terrorist. And this, of course, is not happening in Afghanistan or Iraq. This is happening in Northern Ireland, where UK citizens are affected. So I think that rule of law is vitally important.
Will you give way on that point?
I will give way.
I just briefly wanted to recognise the point that he's just made. You can't have immunity for one group and not another. That's a position that the previous government recognised. It was recognised in their bill, which is why their bill gave immunity to terrorists. Is that not the case?
He is right, and I think it's important that for everyone involved, including the many veterans that are concerned about the situation in Northern Ireland, that we end this legal Wild West. The defective act that led to more litigation, more uncertainty and more distress, both for victims and those who have served on Op Banner, should end. I'll give way one more time and then I must make progress.
It's nothing about the rule of law. This is about, on an industrial scale, the terrorist organisations seeking to rewrite the history of the Troubles and using the fact that the Army and the force of law and order in Northern Ireland have all the records. They have none, and therefore it's a one-sided organisation, it's a one-sided operation.
I thank him for his intervention. I do not have the statistics in front of me, but he will know the overwhelming number of prosecutions that have happened in Northern Ireland have been prosecutions of paramilitaries and terrorist groups, and only one member, one service person, has been convicted since 2010, and that was a suspended sentence. So that the threat is exaggerated for political effect, I'm afraid, by our opponents, and that is not helpful for what is a very serious business that people are very concerned about. It is important we deal in facts, not scare stories. Claims that 800 civil cases will be reactivated and that this will drag veterans through the courts again are simply untrue. The reality is that almost 800 civil cases continued unaffected by the Conservatives' Legacy Act of 2023, as this Act was aimed at new claims, but as the Act was rejected by the courts, it never provided any protection to veterans. We will go on to protections for veterans as part of Labour's new bill. I won't cover that now because we'll have another opportunity to debate, but I will finally end by saying this remedial order is a necessary correction. It removes discredited provisions, restores basic legal rights and helps rebuild confidence in a process that must command legitimacy across Northern Ireland, and I will be supporting this motion.
Members may wish to know that I will shortly be bringing in a 3-minute time limit, but without a time limit, Gavin Robinson.
Very much, Madam Deputy Speaker. Can I say, firstly, in a point of agreement and positivity, can I thank the Leader of the House and usual channels for agreeing that this motion should be 3 hours, because had it rested at 90 minutes, no Northern Ireland voice would have been heard in this debate at all, and I think that would be shameful. So can I thank you for the indication that you will bring in a time limit, Madam Deputy Speaker, and can I indicate that I do not intend to take advantage of my opportunity to speak without time limit, because I'm not going to be discourteous to Northern Ireland colleagues or any other who wishes to participate. Can I say to the Secretary of State, and he knows my position on this, I believe he is bringing this remedial order in wrongly. I think he is attaching to these issues a level of undue haste. I said to him on the 17th of December in this chamber that given that he knows there are issues still before the Supreme Court, he should at least wait. Though he abandoned the appeal, the Northern Ireland Veterans Movement have not. And yet this government, and the last speaker made a valiant effort, have tried to indicate their support for and their understanding of the concerns of veterans. And yet we have veterans waiting on the challenge that they lodged in the Supreme Court. And the government can't wait until these issues have been determined. I say to the Secretary of State again, remedial orders are there to deal with an incompatibility with human rights law, not his policy objectives. And yet that's exactly what I believe he has been doing in this regard. If I'm wrong, then surely it's incumbent upon him to use this mechanism to deal with all the incompatibilities that were highlighted by the courts. The High Court in Belfast highlighted a number, yet he left one out. The Court of Appeal added 3 more, yet within this remedial order he only added 1. And yet the Joint Committee on Human Rights have given their indication that yes, this remedial order should be approved. They have offered absolutely no view whatsoever on the issues that have been left out of this remedial order. But I am going to raise them, because when we mentioned civil cases earlier, the Secretary of State has not reconciled why the High Court in Belfast and the Court of Appeal were in 2 fundamentally different places on civil cases. Nor did he take the opportunity to pursue the differential and get a determined outcome in the Supreme Court. He has not indicated why he believes the High Court in Belfast thought the retrospective application was wrong, and yet the Court of Appeal allow civil cases to be lodged indefinitely and in perpetuity. He posed the question to me when I intervened to him about the matter of principle of bringing civil cases. I agree in the principle of bringing civil cases, but it's not uncommon within the law to understand limitations, and to understand the Limitations Act that we have, and understand the parliamentary sovereignty of this Parliament to be able to say enough is enough, time has moved on, you have exhausted your opportunity for claim, because we know, veterans know, the security services know, the PSNI know about the unlimited quest through legal aid for lawfare to rewrite the past, to rewrite the history of Northern Ireland, and to turn that which was bad into good. And we will always speak out against that. He has chosen to leave out the interim custody order issue from his remedial order. He has chosen to try and attempt to deal with that within the Troubles Bill. Yet I say to him, Articles 89 and 90 in the Troubles Bill will not deal with Gerry Adams. The Gerry Adams case, and if he reads the judgment, Lord Kerr's probably his final judgment before he retired from and sadly demised from the Supreme Court, indicated that that which he applies or intends to bring forward in Article 89 does not stand legally. And in Article 90, Article 90 engages consideration about a conviction that was quashed, remains quashed, but yet there can be no compensation. Silent on whether Jerry Adams would be able to attain compensation, not from the quashed conviction, but from the fact that he was detained without trial under the interim custody order in the first place. Can I say to the Secretary of State, he is deficient in what he has provided towards this House. He hasn't chosen to deal with the incompatibility through the interim, through this remedial order, and nor do I believe, given the path he's taken in primary legislation, dealt with it sufficiently either. On civil cases, the Secretary of State lectures Northern Ireland continually about living within our budget, living within our means. He has expanded the scope of legacy investigations in the Legacy Commission exponentially by the actions of this remedial order and indeed the Northern Ireland Troubles Bill. Has he suggested for one moment that he's going to increase the budget available to the Legacy Commission? No. 250 million over 5 years, almost £100 million already spent. And yet this raft of work that's going to have to befall us in Northern Ireland, is he going to pick up the tab? No, the decisions being made by this chamber now and in the future with the Troubles Bill have material impact on our ability to move on to the future rather than deal with the past, but yet I hear no concern for that. And when I see that 800-odd civil claims now to be accompanied by an additional 200 civil claims, who's to pick up the bill? Secretary of State. If it's the people of the Northern Ireland, if it's the people who were troubled for 30 years by terrorists in Northern Ireland, if it's a fledgling executive which is struggling to make public services deliver for their people because of these issues, then I think that is something I need to raise out of responsibility and something I think he needs to wrestle with and deal with. And then most fundamentally of all, there was a suggestion that this process was to provide an immediate or a quick resolution to an issue raised by the courts. We are now some 16, 18 months on from a manifesto commitment to repeal and replace, and yet what do we hear? This government is locked in logjam between the NIO and the MOD about the substance of amendments that may or may not be brought forward. 2 weeks ago, the government were maintaining the position that the safeguards that they call protections in the bill were sufficient. Only 2 weeks ago, the Prime Minister accepted with me that they were insufficient and he was going to have to bring forward amendments to be shot down by a representative of the Irish government some 2 hours later, who said he, the Secretary of State, has no power to bring forward any amendments unless he attains their agreement. Shame. Shame, I say. It is a matter of fact that that was said by the Minister for Foreign Affairs in Parliament Buildings, Belfast, and well, he knows it. But we'll attest and we'll see the amendments that he brings forward. I seriously and personally regret that we are in a position that we cannot offer our support to this remedial order. I regret that, having asked the Secretary of State on the 17th of December to wait, hearings concluded in October, the Supreme Court will issue a determination he would be in a much stronger space to build credibility and confidence on these issues if at least he allowed the judicial process to conclude. But he chose not to, and with that he loses our support.
Claire Hanna.
Very much. The SDLP welcomes this remedial order, which goes some way to restoring rule of law to legacy processes and to the present day. The introduction by the previous government of an amnesty and the closure of processes was the very definition of the phrase justice delayed and denied. This order specifically is about the Troubles Legacy Bill, but across these islands, I think in every jurisdiction and every day, we can see evidence of cases where wrongs were not properly addressed at the time, and we now see the hurt and the damage compounded by delay. Hillsborough, infected blood, the post office scandal, the Magdalen laundries. There won't be a member of this House who cannot speak to an experience in their own constituency. And my ask is simply that you think about my constituents and people across Northern Ireland in the same way. It's not about who won. I have to bite my tongue quite a lot in this House, and particularly today. It's not about who won. The people who are waiting to access some of these processes, none of them have won. All of them have lost members of the family, and it's not about people being able to draw a line under the past because MPs in London have told them to, and MPs have called them IRA sympathisers. The previous legislation which this undoes was not about reconciliation or truth. The word reconciliation appeared in the title of the bill and nowhere else, but it was about closing down truth and ensuring that Republican and Loyalist paramilitaries again would have had their crimes retrospectively legalised. This wasn't just a free pass for paramilitaries, and I'm not here to write the reference for any of them. Tens of thousands of them did at least go through the justice system, but these provisions and amnesties apply in the darkest corners, yes, of security services, but of those who directed terrorism and who played God with people, and of course who should be held to the law. The Conservatives justified their approach with the fiction that nothing is working. Inquests have worked. They have been belated, yes, because there was a failure to address the crimes at the time or to fund the system, and yes, they have been complex and expensive, but that is because of the layers of veto and information suppression that have been applied by those with most to hide. But they have exposed truth and they have corrected false narratives. I think of the Ballymurphy families, where the parachute regiment, just 5 months before they went on to kill in Bloody Sunday, opened fire on innocent civilians, falsely labelling them as armed threats. The 2021 inquest freed those families, freed people who'd grown up with a lifetime of being told that their mother or their father or their parish priest was a gunman, when it was entirely obvious that that was not true. They finally got accountability from a regiment who operated without it. The false narratives have been used by security forces and by IRA and Republican and Loyalist terrorists to impugn, to add grievous insult to injury to so many victims. I also think of the Kingsmill massacre, where an inquest less than 2 years ago today rightly concluded that that was a sectarian attack. 10 Protestant workmen were murdered in an act of ethnic cleansing by the IRA, carried out by people who claimed the legacy of James Connolly while shooting dead the very people who he would have stood aside. So for people to talk about it being IRA sympathisers who benefit from these inquests is such an insult to decent and non-sectarian people like Alan Black. I particularly welcome the ending of the immunity scheme from the Good Friday Agreement, the bitter pills to swallow in that, and Eames, Bradley and Halesowen and the On the Run letters, and all of these processes that have put the needs of victim makers ahead of victims. This bill is a turning around of that. It's just the beginning. We have to get the processes right if we are to escape the shackles of the past and create a space that is for truth and accountability and remembrance, and that has to be rooted in the future as much as it is in the past, but in human rights compliance and truth and justice too. So again today I urge the Secretary of State and the Prime Minister, where concerns exist around disclosure and ECHR compatibility and judicial independence, we must face down those vested interests in or out of uniform, and you should show Britain as a country, a democracy that upholds laws and the rights. Dealing with legacy won't be confined to this remedial order or the Troubles Bill or the joint frameworks. It shapes, as members from across the House know, our politics, our policing, how communities relate to each other and how we can best deliver a shared future. We can't afford another missed opportunity. The answers won't all be found in this order, they won't all be found in the legislation to come. We've never needed a complex legal process for people to acknowledge what they did, for the IRA to acknowledge that they used human lives, nearly 2,000 of them, as collateral damage, for loyalism to acknowledge that their war was with innocent Catholic, and for the UK security forces to acknowledge that their soldiers did not always uphold the law. I can stand here and acknowledge that so many did serve decently, did try to serve decently. I can stand here and acknowledge the pride that many members here feel in the service of themselves and their loved one, but I hope that others can acknowledge that that was not the experience that everybody in Northern Ireland had. 300,000 soldiers served in Operation Banner. Fewer than 24 of them have ever faced judicial proceedings. We have wasted a lot of time of victims' families, and we have wasted money as well. It is time to move forward. This bill is the start of that, and I would ask that members approach it in that framework and with respect for the dignity of all the people who lost their lives in Northern Ireland.
If members would be able to limit their interventions, I can start with a 4-minute time limit. Gregory Campbell. Sir Julian Lewis.
Thank you, Madam Deputy Speaker. In the limited time available, I shall try and address a few of the basic issues, including the ones on which I intervened earlier. It became fairly obvious towards the end of the Secretary of State's remarks, under questioning from my fellow colleagues on this side of the House, that although there was much in his speech suggesting that he had to do what he's doing today, he's really doing it because he wants to do it. It was in their manifesto that they were going to repeal the legislation, and he is seizing an opportunity to strike it down at the first possible chance that he gets. Now, sometimes one gets into a position of almost wondering about the futility of entering into a debate. 40 years ago, I used to debate against the same people again and again over the question of whether Britain should one-sidedly give up its nuclear weapons. And I would often find that I would put forward an argument that countered something they'd said, they'd have no answer to it, and then I'd go to the next debate and they would say exactly the same thing over and over again, and I would have to put forward the same argument, and no one was getting anywhere. I feel like that over this point about the supposed equating of service personnel with IRA and other paramilitary terrorists. Nobody, and I say it to the honourable gentleman who made the point a few moments ago from the opposite benches, he said there is no moral equivalence between these people. Nobody in this debate is saying that there is any moral equivalence between these people. What we are saying is that everybody is equal before the law. And I have to remind the House of what I said 6 months ago to the day this time last week in Westminster Hall. We had a debate on the 14th of July last year covering all these subjects. And at that time, I pointed out that the Defence Select Committee in April 2017 had published a report on a consensus cross-party basis entitled Investigation into Fatalities in Northern Ireland Involving British Military Personnel. And in the inquiries that led up to the publication of that report, we had taken evidence on the 7th of March 2017 from 4 professors of law. Professor Philip Sands of University College London, Peter Rowe of Lancaster University, Kieran McAvoy of Queen's University Belfast, and Richard Eakins of Oxford University. All of those professors agreed that it was possible and it was legal, whether they wanted to do it or not, but it was possible and it was legal to have a statute of limitation provided it was accompanied by a truth recovery mechanism. That is what the bill that is now being struck down brought into effect. The bill has a very good chance of surviving further legal scrutiny. It is no argument to say that it has been discredited just because the government and its supporters don't like it. The truth of the matter is that you have to give immunity to everyone or to no one. And if the price of giving immunity to our servicemen is that we give it to terrorists too, then it is a price worth paying.
Calvin Bailey.
Thank you, Madam Deputy Speaker. And today I'm going to try and speak as freely as I can about something in which I believe passionately. And I hope to explain why I believe in the principles which are underwriting this bill, and which is why I consider it necessary that we keep working on the specifics during the Cummings Bills phase in Parliament. During this discussion, I'm going to try and explain some of the complexity and emotion and why I find it despicable that some seek to gain political advantage from it on both sides of the chamber. And it's for this reason I'll be circumspect about accepting interventions. I love this country. I'm proudly British, and I'm prepared to fight and die for the protection of the principles and fundamentals which define it, most important of which is the rule of law, and the principle that law is applied evenly to all of its citizens. And I'm also aware that these principles and fundamentals, which have been hard-won, but also most recently during our deconstruction of our post-imperial self from 1945 into the late 1970s and early 80s. And I suggest perhaps that some reflect on this, because it is a time when our behaviour overseas and the way that we behaved in places in which we had sovereignty and where our legal situation was distinct from the law as exercised here at home in the UK was different. This is important because when the UK faced an internal crisis, similar to the crisis it sought to manage elsewhere, it used military support to the civil authority to address it. This, in my opinion, should have been a state of emergency. And under such a state, the government would enact powers not able to it during peacetime, most important and pertinent of which is the ability to deploy its own military on its own streets in the protection of its own civilians. And in doing so, in the issuance of such orders, we should bring with them clear and defined parameters under which those acting as in the supplementary capacity of the police have the rights and authorities to use legal force on behalf of the state in an attempt to save life. That, Madam Deputy Speaker, never happened. Instead, this was done through emergency legislation and security powers. What never happened was the creation of a coherent, unified legal framework equivalent to civilian policing. And it's for this reason that those acts asked to act on behalf of the state have been left in turmoil because the state inadequately defined the parameters under which its servants would act, and the protections and the responsibilities that the state would provide for those actors if those individuals acted in line with the law and the derivations provided to support the Troubles. It is for this reason that immunity from prosecution is not something that we here are being asked of for our police officers. At no point have I heard those arguing for the maintenance of the failed bill arguing that the police officers of the RUC should be given similar immunity, because the context in which they were asked to act was known and the parameters of them doing so was clearly defined. For our soldiers acting as police officers, it was not. Now, I was going to share some of my experiences as a military person and some of the things that have shaped my view of the world, but what I would say...
Order. Unfortunately, the honourable gentleman has reached the time limit. Sir Julian Lewis.
Oh. He's spoken.
I've spoken. And Duncan Smith.
Speaker, I have to congratulate the others that have been before, but particularly the member for Belfast East, who set out, I think, in precise and excellent detail and eloquently exactly what is wrong with what is happening today and will be wrong with what is happening when the government brings forward its next legislation. I do not understand, and I still don't understand, the reason for this rush to get this thing through today. We have legislation coming before us. Surely it would have been reasonable to allow the courts to get on with their business and for us to legislate on the basis of what they come forward to. And I simply say to the government, this is badly done, really badly done, that we are rushing this through and the House is being forced to vote on this today. I also want to make a couple of points, not about the legalities of this, because that's been trudged over endlessly, and as I said, the right honourable member has made a brilliant exposition of that, and there's nothing I can add to that. But I do want to talk simply about what we were trying to do, what the government was trying to do previously when it brought its previous legislation in. I went out back in about 93-94 to South Africa with a delegation to look at how they could bring the country together again and clear themselves of the baggage of what had happened over those desperate years, where many, many more men and women were killed in South Africa than we are dealing with today, tragic as that is. And it was that process and the Truth and Reconciliation process that took place that persuaded me that something along those lines was vitally necessary here for Northern Ireland. I say that as somebody who served in Northern Ireland. I also say it because I'm one of those who lost somebody, I've mentioned his name before, a good friend, Captain Robert Nairac. And the main point I make here is I no longer wish to pursue those people, and the families, the parents have gone and died, and the rest of the family have gone. They don't want to pursue them for justice. They want to find out what happened to Bob Nairac. Nobody knows, and nobody will come forward with the possibility of prosecution hanging over their heads, because what happened there was terrible. But we want to know what, and that is the bit that I feel strongly about, is knowing is important to end and draw a line under this. And I'm afraid that what is coming forward, the legislation, will continue the pursuit of individuals, particularly, as it were, those who are, like me, veterans of this area. And also there is no help here for what will happen over Ireland and their pursuit too. And what are we going to do? There's nothing coming forward that says Ireland will now agree to drop what they're doing and to open their records, because so much of what happened in their records as people fled from their brutal crimes. This is not about equivalence. Because equivalence, as I said before, and was raised earlier by my right honourable friend, back in '98, that was when equivalence came about, when there was a limitation on the incarceration limits that you could have. That brought equivalence to terrorism and to terrorists. The honourable gentleman that spoke earlier, who's not in his place now, he made the point about the vast majority of prosecutions have happened over terrorists. Well, over 3,000 of the deaths were down to terrorists. Only around 300 had anything to do with the armed forces. So, of course, there are going to, so far, been more prosecutions, but there'll never be enough while you cannot get the records that do not exist of those who committed these foul acts. So it is a one-way street, again, as I made the point to my honourable friend. And I had just finish on this because time is absolutely limited. I simply say Norman Tebbit died quite recently. And I remember a conversation with him in which I asked him what was the worst thing that happened to him. He said it wasn't lying under the rubble. It wasn't even believing that his wife had died as she lay next to him after the bombing. He said the worst thing was when he had to swallow hard and watch the person who had set the bomb and blown his wife into a different future. That, he said, was the worst thing, but he understood why it was necessary, and he swallowed on it and didn't determine for prosecution. That is what I was hoping for with the previous legislation, that we could get to the truth of things rather than this ridiculous pursuit that will never end for those gallant veterans who served in Northern Ireland like I did.
Sarah Perchin.
Thank you, Madam Deputy Speaker. This remedial order is just another step by this government towards repealing and overriding the last government's Legacy Act. This government, the Secretary of State for Northern Ireland, the Prime Minister, the Attorney-General, Lord Hermer, who has in the past represented Gerry Adams, claimed that the Legacy Act 2023 is contrary to the European Convention on Human Rights. And there again we hear the ECHR wrongly allowed to interfere in our justice system. The Legacy Act put a stop to lawfare. This Act, whilst not perfect, was a step in the right direction by outlawing lawfare against veterans. However, it also prevented legal action and prosecution of terrorists. This government wants to reopen inquiries, leading to the return of years of misery and stress and persecution of our brave veterans in their retirement years, who served this country so loyally during the Troubles. In the meantime, on-the-run letters of comfort remain in place for IRA terrorists, letters sent by Tony Blair and Jonathan Powell, the current National Security Advisor. The return of civil suits will lead to the return of slow justice and a cost of millions more to the taxpayer. This legislation will serve no purpose other than to pursue our brave veterans. This legislation is unfair and against their human rights, and I will not be voting in favour of this remedial order today.
Yeah.
I call Alex Easton.
Thank you, Madam Deputy Speaker. I rise as a proud Unionist from Northern Ireland and as somebody who stands foursquared with our veterans, innocent victims and their families. I have deep concerns about the remedial order and how this is going to operate. And from the perspective of our veterans who served in Northern Ireland, this entire legacy framework is nothing short of deeply worrying. These are men and women, often now in their 70s and 80s, who put on the uniform of this country, who operated under orders, under rules, under the law, and under unimaginable pressure to hold the line between democracy and terrorism. Yet what is the message that we are sending today? Welcome to Labour's Northern Ireland, where Republicans run around with letters of comfort in their pockets, while innocent soldiers like Soldier F are honoured and hounded through the courts. We are told this order is about remedying and fixing deficiencies in the 2003 Act. It does nothing of the kind. The central obscenity remains: the effective closing down of routes to meaningful justice for hundreds of innocent families, while leaving entirely intact the pattern in which the vast majority of new investigatory energy is directed at former members of the security forces. Let us be absolutely clear. Our veterans did not start the Troubles. They did not choose the battleground. They were sent by this Parliament to defend the rule of law, to protect both communities and to uphold the very democracy that allows some in this chamber to denounce them today. To watch in 2025 as the state bends over backwards to accommodate the sensitivities of those who waged war against it, while putting elderly veterans back in the dock for split-second decisions made in the fog of conflict half a century ago, is to witness a profound moral failure. For the victims of terrorism, Protestant, Catholic and none, this framework still closes doors. It still moves them from a justice-based system to a process-based system, from the possibility of accountability to the inevitability of managed disappointment. They are told to accept truth recovery with no guarantee of truth, reconciliation, with no guarantee of remorse, and closure with no guarantee of justice. For veterans, it is even worse. They see those who tried to murder them or who murdered their comrades sitting in government or appearing on TV, their past laundered and legitimised. At the same time, they see files reopened against them, headlines splashed against them, and their last years overshadowed by legal and political warfare. This is not equal treatment. This is not a balanced approach to the past. It is calculated political accommodation with republicanism paid for with peace of mind of those who serve this country. I say this directly to the Minister. If they will not stand with the men and women who defended this kingdom, do not be surprised when they conclude that this kingdom is no longer standing with them.
Sorcher Eastwood.
Thank you, Madam Deputy Speaker. I welcome this move today by the Government, and I will welcome the removal of the word reconciliation. There's a lot that I'd like to say about this, but we're short in time, so I'll just get to the point. I've heard some remarks today that are incredibly disturbing and distressing, particularly, and I don't want to pick on anybody, but the Right Honourable Member for New Forest East, and I quote, and do forgive me if I misrepresent you, but if the price of giving veterans an amnesty is that terrorists get the same, well then that's a price I'm willing to pay. Well, that's a price I and the people of Lagan Valley and the vast majority of people in Northern Ireland are simply not willing to pay. We have had a conversation today about, oh, we all agree there's no moral equivalence. Fair enough, but I don't know what on earth moral equivalence is, unless it's a situation where terrorists and people who wore a uniform are both given a carve-out from the rule of law. And by the way, None of us get to speak en masse for veterans. I have veterans in my own house. I'm proud of them. And do you know what? They never asked for immunity. In fact, I agree with my colleagues from Northern Ireland whenever they say there's a wholesale rewriting of history. Absolutely there is. It's already in progress. But what I would say is I would simply ask colleagues to stop for pause and think. If there is a rewriting of history already going on, to those who are not present in this house today, who say, see, told you so, they all needed a get out of jail free card because we can't guarantee that every single person that served in Northern Ireland did so honourably and lawfully. Think what that will give them. I don't want that to happen. I do not want that to happen. And where there was wrongdoing, where there is a list of cases, some of the people that I know that served both in the RUC, the UDR, the regular army, will be the first to say, where there was wrongdoing, let us put it right. Because we do not want that to besmirch our reputation. And lastly, we are in a situation, arguably already in hybrid war. We're potentially considering future deployments. I do not want anybody representing the UK to be abroad, overseas, with this hanging over them. I'm proud to be Northern Irish, I'm proud to be British, I'm also proud to be Irish. But most of all, I am proud to say that we should be able to stand by the rule of law wherever we are deployed. We should not lower our standards because we worry about the standards of terrorists and the evidence available to them. We should maintain our rule of law, and I will be supporting this today. Thank you.
Sammy Wilson.
Thank you, Madam Deputy Speaker. Veterans will have heard the honeyed words of the Secretary of State at the start of his speech today when he talked about the debt of gratitude we owe to those who served in Northern Ireland under very difficult circumstances. And yet, this order is all about removing protections that there would have been available to those very veterans against what is a continued terrorist campaign conducted not through guns, not through bombs, not through killings, but through the courts. And I've heard many people on the other side talk about, oh, we've got to uphold the rule of law. That's totally naive. This is not about the rule of law in Northern Ireland. This is about the abuse of the law. The abuse of the law by those who can't accept that they lost in their terrorist campaign, want to rewrite the history of the terrorist campaign, and want to put the blame on the forces of law and order who stood between the citizens and the murderers and the criminals.
I'm grateful to him for giving way. Would he accept that it is not the people on this side of the argument who oppose what's happening today? It is not because we don't wish people who did wrong to face justice. It's because we know that these cases will almost certainly fail, just like the one against Soldier F failed. But as my colleague from the front bench said, the punishment is the process. People will be put through unnecessary hell before they're acquitted. That has nothing to do with justice.
No, it has nothing to do with justice. And the thing is, although the Secretary of State and other speakers today have argued that this is all about helping victims, innocent victims will not get any justice through this system, because who holds the records? Well, it goes to the courts. Are the IRA going to be, are there going to be documentation to bring from IRA campaigns and IRA activities? No, there's not. And people should read the book written by Andrew Stack, whose father was a prison officer in Portlaoise. And he saw 20 years to get justice. And there was one phrase in it that stood out when eventually Jerry Adams took him to meet some of the IRA commanders. On the way in the car, he said to him, "Don't expect too much, because we don't keep records." And that's the problem. The state kept records. The IRA and the terrorists don't keep records and didn't keep records. So it's going to be a one-sided. And I mean, the Secretary of State told us today that as a result of this, it will open 200 new civil cases. 120 of them, he said, were against the MOD. Now, the statistics have been quite clear. Most of the murders were carried out by paramilitaries. Yet most of the civil cases are going to be taken against the MOD. Why? Because, first of all, there is a deliberate campaign to rewrite history, and many of the people who are taking these cases, in fact, the vast majority of people who are taking these cases, want to ensure that they get a case into court, that drag out all of the information which is available, held by the state, and they get a result which paints the picture that the IRA and the terrorists were the wrong parties, and the state were and if anything, this does not give comfort to victims. This only rubs salt in the wounds of the victims. And that's why this remedial order is wrong. The result will be that it gives a chance to rewrite history. It will lead to huge costs in compensation claims, and as has been said, it will also be a warning to people who we call to serve this country in future, that this tactic might be used against them. That's why this is bad. And the Secretary of State knows he didn't need to bring this. I'm not going to go through the reasons given by my party leader in his excellent speech, but he knows he doesn't need to go through this. Why is he going through it? He knows the results of it. Why does he pursue it? I can only assume that, first of all, he puts the adherence to the ECHR above the interests of the veterans, the interests of the victims, and that's a disgrace.
Carla Lockhart.
Thank you, Madam Deputy Speaker. We have been unwavering in our opposition to the notion of immunity. There has never been a justification for arbitrarily closing down legal routes for innocent victims, not in 1998, not during the darkest days of the Trouble, and certainly not today. While the Secretary of State and his party are perhaps late to this party, we do welcome his desire to remove the prospect of amnesty, and with it the perverse equivalence drawn between those brave soldiers and police officers who acted within the law and the terrorists who were intent only on murder and destruction. That moral equivalence has poisoned legacy discourse for far too long. So when we think of today's debate, the government's push to press ahead prematurely with this remedial action is not that we dispute the policy, but the fact that it is rubbing salt in the wounds and will open the floodgates, will not help one innocent victim, but will open the floodgates against our brave soldiers, those who stood as human shield between good and evil. So what is disputed is the reckless manner in which this government is attempting to achieve it. And all to placate Dublin, a government whose approach has always been obstruction and concealment. The fact that the Secretary of State is willing to preempt the outcome of an appeal to the highest court in the land sets a dangerous precedent, and more importantly, it sends a message to the Northern Ireland veterans movement, men and women who have already given more than enough, that their views and their stake in this process are dispensable. It will come as no shock to the Secretary of State that there are aspects of this draft remedial order that we would express grave concern about. It is clear that any benefit of reinstating civil cases will be accrued by a subset of victims whose claims are directed towards the security forces. Once again, the full weight of the state is being aimed not at terrorists, but at those who stood against them. And, Madam Deputy Speaker, where exactly does the Right Honourable Member suggest those bereaved at the hands of terrorists can seek compensation from the Provisional IRA, from an organisation that still refuses to disband, disarm fully, and even acknowledge the scale and brutality of its crimes and murders? Innocent victims and our brave ex-service personnel are crying out for fairness, not arrangements that aid and abet the rewriting of history, a history which terrorists are daily being recast as victims and soldiers as villains. The Secretary of State seems content to acquiesce to those who would use the courts to distort the truth of the past. This House should be under no illusion. This is not about justice, it's about narrative. And we only have to think of Goole. Let us be absolutely clear about what Goole was. Not a tragic accident, not a miscarriage of justice, but the right and proper action on the part of brave soldiers to halt and take out an armed terrorist unit on the verge of carnage. Yet decades later, the full machinery of the state is being turned against those who prevent a massacre when the Secretary of State backs this latest inquest. Meanwhile, families devastated by IRA bombs and bullets continue to wait, many without answers, many without justice, and many without even acknowledgement. So today, this is not about truth. It's about blurring the distinction between those who served the law and those who sought to destroy it. It's time for this government to show the resolve that it's needed to defend those who defended us, not with warm words, not with platitudes, but with action. This remedial order fails in that aim. It weakens protections, embolds lawfare and abandons veterans to endless legal jeopardy, and we cannot and will not support it.
Jim Allister.
Madam Deputy Speaker, on the first Sunday of this year, I stood with the families of the innocent victims of the King's Mills massacre as they marked 50 years from that horrendous event. It would have been fitting if the Secretary of State had been there. He was not. And last Sunday, another commemoration to mark the equally horrendous sectarian murder of more Protestant workmen at Benn. And the common denominator of victims and families such as that is that they know, not just feel, they know they are the forgotten ones. They know that they are not the priority of this government. And they do know that the country that gives shelter to the murderers of their loved ones are the priority of this government. Dress it up as he will today, the Secretary of State's remedial order is motivated by one thing and one thing only: appeasing the government of the Irish Republic, which wants to drag this United Kingdom before the bar of the European Court of Human Rights. That's what this remedial order is about. It's not that it's to cease to implement laws with which they disagree, because those aspects of the previous Legacy Act are already removed from effectiveness. Just look at paragraph 6.7 of the explanatory memorandum that comes with this remedial order. It says, although the provisions declared incompatible with the ECHR by the High Court in Northern Ireland have also been disapplied. They're gone. The government considers it important to remove these provisions from the statute book swiftly. Why? The answer is the one I've given: to appease the Dublin government. And indeed, the Secretary of State came pretty close to confirming that when he said in this House this afternoon that if and when this remedial order goes through, it's his view there would be no basis upon which to continue the Republic of Ireland's action. And that is the problem. We have a Secretary of State that is genuflecting to the Dublin government. And that is the feeling of innocent victims in our country. They are forgotten, but worse than that, they are way down the queue when it comes to a government that is interested primarily in facilitating those who give the shelter to their killers. There is no legal justification for this. It's quite clear under Section 10 of the Human Rights Act that there is a live issue before a live case in the Supreme Court. It's the issue of whether or not Article 2 of the Windsor Framework, which was used by the court, as I demonstrated in the interventions, to require these provisions to be disapplied, whether or not that was a valid basis for disapplication. That is a live issue. And therefore, there is no legal justification, quite the reverse, for this remedial order, which drives us to the conclusion that it is for the reason I've said.
I call.
Deputy Speaker,
myself and my party, DUP, stand squarely.
You take an intervention? The Honourable Gentleman take an intervention? I'm grateful to the Honourable Gentleman taking an intervention, and I'm sure that what he's about to tell us will be very important, and I wonder if he would just take a deep breath and give us his counsel.
Jim Shannon.
Honourable Gentleman for the intervention. The door to justice must remain open. No equivalence can or should be drawn between the innocent victim and the perpetrators. Every family deserves a full and fair investigation into the death of their loved ones. And there should be no appropriate safeguards against vexatious troubles investigations. So I'm here today, Deputy Speaker, to speak on behalf of all those families who seek justice. My family seeks justice. Honourable member seeks justice for his friend and his comrade. And it's for them. I underline the major flaws in the bill. The bill does not provide protection for service personnel. The recent history of members of the security forces being maligned and dragged through the courts as a result of vexatious allegations. Let us never forget these stem from an attempt to whitewash the history of the Troubles, which was overwhelming paramilitaries murdering and maiming at their unjustifiable will. Let me be clear, I talk about those with clean hands. The announcement of the Irish government's role in this process, considering its perceived inaction on legacy issues within its own jurisdiction, includes a parallel inquiry into the Omagh bombing, is yet more salt in the wind of those who watch murderers skip over the border without impunity. The reason we do not trust the Irish government on legacy issues is clear and is warranted. It's a murder haven for years. Without this, there can be no Irish influence. Anything less than this is the greatest insult to the memory of those murdered and the families who grieve them all. The fact of the matter is, you can never acquit the death of a terrorist killed when carrying out murder.
For Gavin Wen, he'll know the respect with which he's held in this chamber for raising attention to the matters of terrorist atrocities over many years, and on both sides of the House. We're very keen to hear his story, so we just like him to take a moment and we'll look forward to hearing that.
Jim Shannon.
Honourable friend for that. And the fact is, my cousin Kenneth Smith and his good friend Daniel McCormick were murdered on an ambush on their way to work on the 10th of December 71. 54 years ago, no justice for my family, no justice for young Daniel McCormick. Their only crime was to wear the uniform of this nation. And because they were in the UDR, they dared to cross the religious divide. Daniel was a Roman Catholic, my cousin Kenneth was a Protestant, and protect their communities from evil men. And on the 10th of December, they were slaughtered, leaving their wives and their 3 young children behind. They escaped across the border. That haven, that murder haven in the Republic of Ireland, and they escaped across the border. Stuart Montgomery, 18-year-old, murdered by the IRA outside Pomeroy. Never any accountability for his family. Winston Donald, murdered by the IRA on the 9th of August 71, manning a checkpoint outside my Aunt Isabel's farm down at Clady. When they shot him with the Thompson submachine gun, they drove across the road to Clady, cleared the bridge, and where did they go? To the Republic of Ireland. Raymond McCord, I don't know if Raymond's watching this, I'm sure he is back home. His son was murdered by the UVF, and because he stood up to him. He seeks justice as well. I seek justice for him, and I put it on record. The bill does nothing for those mourning families, nothing for the families of the Ballyduggan 4. On April 9, 1990, near Ballyduggan, Downpatrick, a fatal provisional IRA blew up 4 men, 3 of whom I knew. Private Michael Adams. I worked with him in a butcher's shop. I served with him in the Territorial Army, and he joined the UDR. Private John Birch. The day he was born, I remember John Birch. And he died as well. Lance Corporal Bradley from Dundalk, didn't know him unfortunately, but he deserves justice. Private Stephen Smart from Newton Ards, I know his dad and the family really well. They were killed. The explosion was massive, killing the 4 men in the second vehicle instantly, creating a crater some 50 feet long. But the point I want to make is this. This bill does not protect the RUC officer who shot the man who pushed the button, who blew up the force. Callum Marks, and I'll put it on record in this House, he was a murdering scum of the IRA commander in Downpatrick who killed those 4 UDR men. Was he ever made accountable? No, he wasn't, but he did get his account in one time. Because in Downpaddock, when he tried to set up a horizontal mortar bomb, he was shot by an RUC officer who was then taken and charged, but the investigation was found that he was not guilty. But the point I want to make is this: we need protection, we need to make sure. So I'm going to finish with this. I'm sorry, Madam Deputy Speaker, for going on me, but I apologise for my tears. I find it very hard to express things on behalf of people that I serve with and you. So I'm asking the members in this House to ask themselves this: will this legislation do what the Troubles legislation was intended for and provide justice? No, it won't. It will help my cousin Shelley and my family and all the other families, and the family of Private Stephen Smart, that lovely young boy and the family I speak to down the street in Newton Ards. No, it won't. Will this legislation enable the continued persecution of RUC, UDR and British Army veterans, many of whom have had their honourable service doubted and their service disputed and who deserve better from this House? The question is, will this bill help to bring healing or comfort? I doubt that, and the answer is no, it will not, and therefore I believe tonight it must not pass.
Robin Swan.
Thank you very much, Madam Deputy Speaker, and I think, can I ask the House just to pay tribute and actually acknowledge the contribution from our honourable friend from Strangford? Because, Madam Deputy Speaker, that emotion, that story, that heartfelt contribution to today's debate is replicated across many houses across Northern Ireland and indeed this United Kingdom in regards to those who lost, both at the hands of terrorism and in other circumstances in Northern Ireland. But that emotion is also one that is felt by our veterans. And when this place talks, and it is only when I come into this place that I realise, as a Northern Ireland politician, when I speak of a Northern Ireland veteran, we speak of the RUC, the UDR, the home regiments, those who served, the member from Strangford's family and relatives, and all those who contributed, but all those who went home at night. All those who didn't know if their colleague working beside them was actually that individual who was passing the information to the person who was in planning their death and murder in regards to that. But when I came here, when I realised the conversation that is of Northern Ireland veterans, of those from England, Scotland and Wales, who came to Northern Ireland to serve, to defend and protect what we saw and what we believe was a democratic system in regards to our rights and our beliefs. So, Madam Deputy Speaker, it's when you take that context in regards to that emotion, that service, and then when you look to what has actually been brought forward to this House, and what has been asked of members of this House, and what has been asked of members of the government, and I've respect for many of them. But throughout this 3-hour debate, no harm to the government, your benches were empty. But you see, when the bell rings, they will come and they will do what they have been bid to do. Madam Deputy Speaker, in a complete contrast to Monday evening, the question has been raised, why are we rushing this remedial order where there is no legacy Troubles bill to take place in regards to that? Why the rush? On Monday evening, and I quote the Private Under-Secretary of State for Justice when she spoke on the Public Office Accountability Bill, we must think about all the possibilities and scenarios and unintended consequences. It is right to acknowledge that this is not a simple issue. The government remain resolutely committed to finding a way forward on this, which is why we have taken the decision to delay. Madam Deputy Speaker, if it was right for the government to do that on Monday evening, it is right for the Secretary of State to delay this remedial order until the judge and the courts have had their opportunity to complete their processes in regards to what is right, what is just. And then this House can have that legal, informed debate on why we should be moving forward in this. I want to reference two contributions that were from the government. The Honourable Member for Putney in her contribution, and I have a lot of respect for her when she served in the Northern Ireland office, referred to how rare it was to use this remedial order. So why use it in haste? Why not take the time to actually take time to reflect on what it is in regards to those parts that are being removed? Because it was the member for Middlesbrough that actually said part of the legislation that has been reviewed have actually never taken effect. So why the rush to bring this remedial order?
Lincoln Job.
Madam Deputy Speaker, I want to make a couple of points. One about democracy and one about service and justice. I'm deeply uneasy about this remedial order being brought in today. And I'm going to make no criticism of those who are here, but for major parts of this debate over the last 3 hours, the government backbenches were empty. And yet 20-plus veterans have stayed in the public gallery to watch our proceedings and to see justice being done. And I find it very worrying. And as the member for South Antrim has said, it's 6:57 in the evening on a Wednesday. There will be members in the tea room, there will be members in the bars, there will be members working hard in their offices. And the bell will ring, and they will come down and they will ask each other, what are we voting on? And they'll say, oh, it's a Northern Ireland thing. And what they won't realise is that this remedial order removes a law from existence before another one is put in place. And I haven't got time. I really don't think that we are doing the House justice, or indeed Parliament justice, in proceeding in this way. The other point that I want to make is that I was a soldier for 25 years. I spent 3.5 years in Northern Ireland. I once made the mistake of saying that to Ronnie Flanagan, and he said, I'm only on my first tour. But he was the chief constable at the time. And soldiers put up with a lot. I wasn't really given by this House any more powers than a private citizen, not really. Yep. They just slung a rifle round my neck and sent me off to do the Queen's bidding. And I happily did it, and so did others. And in my first of 4 Northern Ireland tours, 2 guardsmen, Guardsman Fisher and Guardsman Wright, were in a judgmental shooting situation, and they were convicted of murder by one man in a diplock court and sentenced to life imprisonment. So soldiers put up with stuff. But one of the things I find very difficult to put up with is that when all the government members troop through their lobby tonight, they will remove the prohibition on giving Gerry Adams compensation. And I find that incredibly difficult because it's on an admin error. His internment order was signed by a Minister of State and not the Secretary of State. And it's on that technicality that he will be able to get compensation for being interned. He will be able to get compensation for trying to escape unsuccessfully twice. So he'll get a triple whammy of compensation. I won't. But I challenged the member for Halesowen earlier on and said, please speak to the veterans and please speak to the members of Halesowen and justify why that's okay and why he's prepared to go through that lobby to vote for that tonight. And he said, because the Prime Minister's told me that that's okay. He's not going to allow it. Because I heard him here at PMQs. He said, we're not going to allow it. And maybe he just wasn't aware, and I'm delighted to see him back in his place. Maybe he wasn't aware that immediately after that, the Prime Minister's official spokesman said, his official spokesman said that he could not guarantee that compensation payments to Mr. Adams and other former Troubles internees would be prevented. So he's completely free to wander through the lobby in blissful ignorance of the fact that actually what the Prime Minister said doesn't amount to a hill of beans. And if he can just summon up the courage, he should at least abstain.
Secretary of State.
Thank you very much indeed, Madam Deputy Speaker. We've had a very full and a wide-ranging debate in which many different contributions have been made, which, if I may say so, have demonstrated once again just how difficult dealing with legacy is. That is a truth, I think, around which we could all rally. If it was easy, it would have been dealt with a very long time ago. But because it's difficult doesn't mean that we should not attempt to deal with it. Now, the honourable member for Brentwood and Ongar, he made his case. If I may say to him gently, I was slightly disappointed by the bit he got to at the end when he suggested that the government was doing this for reasons that are in some way hidden or unknown or may only be discovered in the years to come. I hope he would accept that the reasons the government is doing this are very, very clear. First of all, to deal with the failure of the previous government's Legacy Act, for the reasons that I tried to set out in my opening remarks. Failure legally, and failure because it gained no consent from the people in Northern Ireland. Well, yeah, I will give way.
I thank the Secretary of State for giving away. He said there was no consensus in Northern Ireland. Listening to the speeches tonight, does he believe his approach has achieved that?
Well, I will come on to that point. Indeed, I'll take the opportunity to make the point now. I listened very carefully to every single contribution that's been made. I think it is fair to say that a majority of people who've spoken in this debate do not agree with immunity. Now, they may not all be voting for the remedial order tonight, but they do not agree with immunity, and that is the position of the government. And I respect those who take a different view. I think it was a failed policy. It doesn't exist. So we are charged with taking away something that doesn't exist, never enacted, and found incompatible by the courts. And indeed, of course I will give way.
It's very generous of him to give way. Will the right honourable gentleman accept that conditional immunity, which is all that was in the Legacy Act 2023, the conditional immunity was the very foundation of all the legislation that was passed after 1998, and for the Labour Party to pretend now that it is in some way morally abhorrent is utterly inconsistent.
What I have said to the honourable gentleman is that the government does not agree with the conditional immunity that was contained in the Legacy Act. Now, the word conditional is always used like, well, it didn't necessarily guarantee that it would be granted. But I would urge members who think that to go and read the legislation that the last government passed. What it said was, if someone comes forward, whoever they are, and gives a full and truthful account, which persuades the Commission that it is a full and truthful account of what they did, which would have been a criminal offence, the legislation said, not, well, you can make your mind up and decide whether to grant it or not. The legislation that the last government passed said the Commission must grant immunity. Well, in those circumstances, it doesn't sound very conditional to me. I'm going to make progress because I am trying to respond to the many, many points that have been made in the debate. And the second reason we are doing this is because we want to enable those who are still seeking answers to be able to seek them in a system that they can have confidence in. And there has not been the confidence in the last government's Legacy Act for reasons that we've heard, including from members from Northern Ireland. Now, the honourable member for Wimbledon made a very powerful contribution in defence of our human rights obligations, and I'm grateful for him and his party's support for the remedial order tonight. We've also heard very important contributions on both sides of the argument, and I recognise that, and I recognise the sincerity and force with which those arguments had been put on this side of the House. My honourable friends, the member for Middleton and Thornaby East, for Bracknell, for Halesowen, for Leighton and Wanstead, if I may say, the members for Belfast South and Middown and for Lagan Valley both made extremely strong and well-argued cases. I would say to the right honourable member for Belfast East, he says wait, and he's of course perfectly entitled to advance that argument, but he is of course one of the majority who've taken part in the debate who is in favour of getting rid of immunity, which is what the remedial order does. I would say to the honourable member for North Antrim, he said nobody's interested in those who were affected by the Kingsmill massacre. I disagree with that. The Kingsmill massacre, as he will know, is currently the subject of an investigation by the Legacy Commission, and I really hope, along with all of those investigations, it is able to make progress. On the interim... yes, of course.
I'm grateful to the Secretary of State. I understand why he focuses on amnesty, because it means he doesn't have to focus on the things that he didn't include, which are also incompatible, or the other things that are included. But can he indicate to the House what he will do if the Supreme Court says he is wrong, and therefore this remedial order was wholly inappropriate?
Well, I say to the honourable gentleman, we are all subject to the decisions of the courts, and it is a hypothetical question he asked, and like the answer to all of those, we'll cross that bridge if and when we come to it. Could I say to the honourable member for Spelthorne, I'm afraid he's just wrong on the question of interim custody orders, because he has not caught up with actually what the government has done. The one difference between the first version of the remedial order and the one that we are debating tonight is the government listened to the arguments that were made, which said, why are you removing, why are you taking off the legislation sections 46 and 47 that were added very late in the day of the consideration of the Legacy Bill in an attempt to deal with the consequences of the 2020 Supreme Court judgment, which did not uphold the Carltona principle. Carltona principle, as the House knows, has long held anything signed by a junior minister has the force of a signature of the Secretary of State. The Supreme Court decided in that case they would not apply that to the signing of interim custody orders. We decided to leave that defence there, even though it's proved flimsy, because it didn't win out in the Fitzsimmons case, and we are bringing forward legislation in the bill, which the government thinks will do the task of restoring the legality of those interim custody orders that were signed, whether it was by the Secretary of State at the time or other ministers. And I think that that is extremely important indeed. On the ICLVR, and the honourable member for Chingford talked about his friend Robert Nairac, we all are living in hope that he and the other 3 sets of remains will be found. But what the ICLVR did was to say, if you give information about the location of remains, anything that is found will be regarded... I'm not going to give way because I do want to respond to the other points that were made. Anything that is found and the information you've given us cannot be used in a prosecution. That is what's known as a protected disclosure. A protected disclosure that the last government agreed to when it reached the Stormont House Agreement, when it came up with the idea of the information recovery body. That is going to form part, it is part of the Troubles Bill that the government has published, but there is the world of difference between a protected disclosure and immunity from prosecution. Now, the other points I wanted to make were this. It has been suggested that this is about relitigating who won. And I would say that that answer is already crystal clear. Peace won. Peace won in Northern Ireland because of the Good Friday Agreement. It is not about placating anyone. It is about seeking to do the right thing. And it is not about dredging up the past. No, it is not about dredging up the past, because I have met, and many other honourable and right honourable members will have met, far too many people, the families of victims, who live with the past every single day and have done for the past 20, 30, 40, 50 years. And my honourable friend, the member for Strangford, laid bare the pain and the sorrow and the heartache that the loss of loved ones has caused to so many people across Northern Ireland. And that pain and sorrow and heartache is as powerful today as it was, I suspect, on the day that they first heard the news of the death of their loved ones. And what the government is seeking to do is to put in place a system which more people can have confidence in, because there was not widespread confidence in the government's Legacy Act on the part of victims, survivors, political parties and others in Northern Ireland, so that where it is possible, answers can be found. We all know. You only have to look at the figures for prosecutions. They are diminishing. They're diminishing rapidly. There are 9 currently live. By the way, 7 of them relate to paramilitaries. 1 relates to the army. So when it's said this is only about the armed forces, that is not correct, because that's not what the evidence shows currently. There are 9 live cases, 7 relating to paramilitaries, and I hope that in due course, and we will return, of course, to the Troubles Bill when we come to the committee stage, that the House will be able to come together to fashion a system that more people can have confidence in, so that the people that we have met, the people we have heard from, who are still tortured by the fact that they haven't had answers as to what happened to their loved ones, may have the chance to find that answer. And it is in that spirit that I would ask the House to support this remedial order.
The question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. The question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Nesel Khalitskan and Mark Ferguson. Tellers for the noes, James Wilde, Harriet Cross. Order, order.
The ayes to the right, 373. The noes to the left, 106.
The ayes to the right were 373. The noes to the left were 106. So the ayes have it. The ayes have it. Unlocked. Point of order.
Briefly in my opening remarks, but I just do want to place on record appreciation for the agreement that this evening's motion could be extended for